We have 2 rooms at the jail that connect, and what you're seeing in the bottom corner is what's called the Polycom room.
Okay.
And Judge Patterson's using the other one, so we'll be reserving this one all afternoon. The problem is my corner picture is over it. I wonder if I can move that.
Oh.
Have a seat right there.
Good afternoon, Mr. Weis. Can you hear me?
Yes, good afternoon, everybody.
Good afternoon. Everyone is here. Deputy Herman, I'm going to put you in the waiting room, okay?
Okay.
We'll be back with you. I just wanted you to know you're connected. And I've got Galaxy Note 9. Let's see who this is. That is, I believe, that Jody Hughes. Jody, is that you?
Yes, Your Honor.
All right, let me give you a name. All right, I'm going to put you in the waiting room along with the other officers. If you had a deck of cards, you could play electronic euchre somehow, but you're going to be waiting for a while. We'll be back with you, okay?
Okay.
All right, I'm going to turn the record on. This is the time and date for the preliminary examination in the matter of People versus Ethan Nicholas Dingman. Mr. Dingman, can you hear me?
Yeah.
I think it's okay to take your mask off. We've met before. It's been some time. I saw you at the early part of the proceedings, and then Judge Patterson handled some things. I'm here once again. Your lawyer, Mr. Weis, is here. Amy Shepard, the special prosecuting attorney, is here on behalf of the state. Also present is Chief Mark Brinkert from the Colon Police Department, who's the officer in charge of this case. We have a couple of spectators whose cameras are turned off and their microphones are muted, but they're here on representatives of the victim and the defendant, and they're watching. We are live on YouTube and we are on the Zoom platform, and this is being recorded. We also have several people here in the courtroom. In the waiting room, we have Trooper Elizabeth Burgoyes, Detective David Males of the Sturgis Police Department, Deputy Jody Hughes of the Sheriff's Department, and Deputy Dan Herman of the Sheriff's Department. Mr. Dingman, let me tell you, I told you this months ago, but let me tell you once again, you're charged with open murder, sometimes referred to as the statutory short form murder. It's alleged that November 21st of 2019 in the village of Colon that you did murder Todd Schwarz. That is a felony punishable by life imprisonment. The attorneys have done a lot of work in this case up to this date. You spent a number of months at the forensic center and some related hospitalizations. After a lengthy hearing, Judge Patterson issued an order finding that you were competent to proceed to preliminary examination. That order was signed it was filed April 30th. And the matter was set for preliminary examination before me here today. Ms. Shepard, are the people ready to proceed?
Sorry, Your Honor. The one thing I was just sending an email to check is I believed that Dr. Joyce D should have been in the waiting room as well. We had confirmation from her office that she could participate today, but it doesn't sound like she was currently in the waiting room. I just sent an email to her assistant. Even if she's not in the waiting room right now, we could proceed, yes.
All right. And Mr. Weise, are you ready to proceed?
Yes, Your Honor.
All right. Now, I don't want to keep mispronouncing your name if I'm saying it wrong. That's how I've been saying it since we met. But how do I say your name? Mr. Weise?
You got it, Your Honor. Bill Weis.
All right. Okay, Weise. That's the way I thought it was. All right. Mr. Dingman, can you hear us?
Yes.
All right. Thank you. Madam Prosecutor?
Thank you, Your Honor. Before we begin with proofs, we do have a few stipulations that I believe we can put on the record. The first is that Dr. Joyce D, when she does participate and is here, we were stipulating to her testifying as an expert in the field of forensic pathology. So we do not have to go through the initial qualification part of her exam. Secondarily, I have sent copies of people's proposed exhibits 1 through 14 to Mr. Weise. My understanding is that he would stipulate to each of those for the purposes of exam only for their admission at preliminary examination. Finally, we have one more stipulation that the items described in people's exhibits 13 and 14, the 2 Michigan State Police Crime Laboratory reports, that those are the same items that were recovered from Mr. Dingman during the course of this investigation. The stipulation is for chain purposes, that there wouldn't be a challenge to that. Again, for the purposes only of preliminary examination. I believe that that summarizes the totality of the stipulations that we have at this point.
Can you hear me now?
Yes.
We had a failure for a moment. That's never happened before. Mr. Weise, can you hear me?
Yes, Your Honor.
All right, I gotta. Hopefully it didn't disrupt our live chat. Dr. DeYoung is here.
Okay.
Give me just a moment. That's never happened before, to my knowledge. Yes, all right, we're good. All right, secondly, you're going to, for preliminary examination purposes, stipulate to exhibits 1 through 14 of the people. Is that correct?
It is.
And thirdly, you will stipulate for preliminary examination purposes only that the items referred to in exhibit 13 and 14 were obtained from the defendant.
That's correct.
Ms. Shepard, do you wish to make any sort of opening statement or simply proceed with the proofs?
I'd like to just proceed with the proofs, and the first witness that we would call is Dr. Joyce D.
All right, give me just a moment. Good afternoon. Are you Dr. Joyce DeYoung?
I am, and I was in the wrong courtroom, so I'm sorry that I'm late.
Oh, you're fine.
I ended up with a different.
Well, there were
judge.
some changes. You were in Judge Patterson's courtroom the last time. I'm Judge Middleton. we've met over the years. You may not remember me. I was a witness in a Kalamazoo case that involved a 18-year-old homicide that occurred when I was prosecutor. And I may have dealt with you a time or two when I was the county prosecutor.
Sure.
But you're in the right courtroom. And
Okay.
so I'm going to start with asking you to raise your right hand, if you would. Would you state your name for the record?
Joyce Lynn DeYoung,
You spell your last name, please.
DEJONG.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, I do.
Madam Prosecutor?
Thank you. Dr. DeYoung, before bringing you into the Zoom room, we have already stipulated to your expertise in the field of forensic pathology. But if you could please let us know where it is that you work and what it is that you do there.
So I work at the Western Michigan University Homer Stryker MD School of Medicine. I am the chair of the pathology department here, but part of my duties are to serve as a medical examiner for multiple counties in Michigan, including St. Joseph County.
And as part of being the medical examiner for these various counties, including St. Joseph County, is part of your responsibility to perform autopsies on deceased individuals?
Yes.
And is part of that to determine the cause and manner of death for these individuals?
Yes.
And is there a standard procedure that you follow to conduct this type of investigation?
Yes, there is.
And what's that standard procedure?
The standard procedure is to first gather a little bit of information about the circumstances in which a decedent was found. We then, that's just a routine matter before we actually look at the body. We then examine the body externally, however it's received, whether there's, and if there's clothing, we look at the body, we gather photographs with the clothing and personal effects on. Those are then removed. And the body is examined again without any clothing or personal effects on, and significant findings are noted, features of identification, that type of thing. We'll collect body fluids for toxicologic and sometimes other testing. We then do an internal examination where incisions are made into the chest, abdomen, and the head so that we can see the organs of the neck, chest, abdomen, and the organs and the brain itself. Following that, we'll also do x-rays as indicated. I then take all of the information that's gathered from the examination and I will form that into a report that's issued that documents those findings.
Now, were you employed in this capacity on November 22 of 2019?
Yes.
And in this role as medical examiner, did you perform an autopsy on a Todd Schwarz?
Yes, I did.
And how were you able to identify Mr. Schwarz?
I believe he was identified to us just by a government ID, and then he had tags attached to him that reflected that.
And did you follow the standard procedure that you just outlined in your performing of an autopsy on Mr. Schwarz?
Yes, I did.
And in the course of conducting that evaluation, when you got to the portion of making an examination of his body, did you find any injuries on his person?
Yes, I did.
And what injuries did you find?
So I'll just largely, I'll start at the head and work down, if that makes sense. There was a laceration, which is a break in the skin on the back of his head in the area of the occiput, which is just above the neck, but on the back of the head, there was a laceration in that region. And do you want me to just stick right now to the external injuries, or should we include internal as well?
You can include the internal as well.
Okay, so there was this laceration on the back of his head, the tear in the skin, and there was a lot of hemorrhage of the tissue surrounding that. When we reflected the scalp, we could see that there was significant tissue damage to that area. The skull itself was intact, but there was a bruise on the brain on the opposite side. so the bruise on the brain was actually in the front of the head, which is something that happens. It's something called a contre coup injury. It means that there was a strike to the back of his head and the brain traveled frontwards, and then when it struck the front of the skull, it bruised. So that's a contre coup injury to the front of the brain.
I believe that's French. Could you spell that for
Sure.
them?
I believe it's spelled CONTRECOUP, contre coup.
Or maybe Latin, but all right, thank you.
Then the other significant findings on the head, including the face and some of the other surfaces like around the eyes, even inside the mouth, were petechiae, a lot of tiny pinpoint hemorrhages that were visible on much of his face and on the mucosal surfaces of the eyes and the mouth. The examination of the neck was significant. On the outside of the neck, there were a number of contusions or bruises and just red erythematous meaning red marks on the outside of the neck.
All right, now, I know petechiae, and we can certainly see that. What was the other term you just used?
Erythematous.
You're gonna,
I'm gonna do my best spelling that. ERYTHEMATOUS. I believe that's correct. Erythematous.
all
It
right.
basically means there's erythema. There is redness on the front of the neck. There were multiple red marks and bruising on the front of the neck. On the inside of the neck, there were injuries. There were areas of bleeding on the inside, and the thyroid cartilage, which is basically the Adam's apple or the voice box. This too had, it was fractured in 3 places. The other significant finding, and I'll group this with the neck because it's part of the exam that we do with the neck, is that we looked at the tongue as well. And the sides of the tongue also had hemorrhages as if he had bitten his tongue on both sides in the back. There was hemorrhage there. On the front of the chest, moving down now, there were multiple bruises on the front of his chest, and then there was actually when we reflect the skin away from the chest, we could see that there was also some hemorrhage beneath these areas as well, between the skin and the sternum and the chest plate as well. Those were the kind of summary of the injuries that we're seeing.
Based on your expertise, are you able to tell what, I guess, let's go back from the beginning of the injuries that you discussed. In regards to this laceration, the part of the body where this located, how much bleeding, if any, would you anticipate to come from that type of laceration?
Well, it was a scalp injury, and the scalp has a lot of blood vessels, and I would expect a fair amount of bleeding to come from that. It was like a full thickness injury, and I'm going to look at my autopsy report a second so that to refresh my memory on how long it was. Yeah, it was 1 3/4 inches long, so a fairly significant tear in the skin, and like I mentioned, I would expect a fair amount of bleeding to come from that.
And then in regards to the hemorrhaging in the skin in that area, what would cause that?
Well, it was a blunt force. The pattern of injury is the pattern that we see when a moving head strikes an object. So that would have been either from a fall or from a shove or being pushed. But when the moving head strikes an object, it will cause this tear in the skin, but then almost simultaneously the bruise to the front of the brain.
Right. It's the contre coup injury that you earlier described.
Correct.
And then in regards to the petechiae that you found on the face and the mucous membranes of the eyes and in the mouth, what would cause that type of injury?
Petechiae can be caused by a number of sources. They're not necessarily specific for example, for a strangulation.
Mhm.
But they certainly are oftentimes seen in association with strangulations. So, but other people with, women might have facial petechiae during childbirth, just anything that causes significant increased pressure of the vasculature, the blood vessels within the within an area, in this case in the head, that would cause these petechiae. So they're small vessels that rupture.
And moving on to then these injuries that you found on the neck, the contusions and bruises and red marks on the neck, were you able to determine what would cause these types of injuries?
Well, those types of injuries, they are also in general a type of blunt force. But in this case, when we're looking at everything and putting everything together, these were blunt force marks, most likely from hands. It didn't, although I can't rule out there wasn't some kind of ligature involved here, but these are injuries to the neck from likely from hands.
And would that type of injury be consistent with a strangulation?
Yes.
And in regards to the injuries that you indicated with the thyroid cartilage and the hemorrhages to the tongue, would that also be consistent with a strangulation injury?
The thyroid cartilage fractures are, the tongue not necessarily, no. It's consistent. These tongue injuries are fairly specific for someone biting their tongue, which may occur during a number of scenarios. One of them is just if somebody had a seizure or something, but it'd be from biting their own tongue.
In regards to the multiple bruises and hemorrhaging that you found in the chest area, were you able to determine what might inflict that type of injury?
Well, these are also blunt force injuries. I can't specifically say what caused them, other than there was some blunt force that was applied to the anterior chest wall, and whether, you know, that's about what I can say. Some of them actually look somewhat linear, but I don't know what specifically it was that caused those. They're not specific enough to say, well, this was caused from this particular object, just that they're there.
Based on your examination of Mr. Schwarz in this matter, were you able to form an opinion as to his cause and manner of death?
Yes.
And what opinion did you reach?
So my opinion as the cause of death of Mr. Schwarz was multiple injuries, including strangulation and blunt force.
And was that based on the observations that you made that you've just testified to?
Right, and it's sort of putting everything together.
And when you say strangulation, can you kind of describe what it is, what you mean by that?
Sure. So strangulation really, it's in this case, it's compression of the structures of the neck, resulting in inadequate supply of oxygen to the brain. So, so by compressing both blood vessels that supply blood to the heart, blocking the blood from returning from the brain, and then also airway compression.
Now, in regards to these blunt force injuries that you've observed, as well as the injuries that were consistent with a type of strangulation, are you able to determine whether they were all inflicted at the same time or if one was inflicted before the other?
They looked consistent with being around the same time. However, in and of themselves, it's not, you know, if I look at the entire picture, including just, we had an investigator out with scene photos and recognizing that, the position that Mr. Schwarz was found in with the blood pooling around his head and these injuries on his neck, it certainly, I believe he was alive when the head injury, he certainly was alive when the head injury occurred, and he was alive when the neck injuries occurred. So I can't, I don't believe that I mean, when I look at the totality of everything all the information available, I believe they all were at about the same time. But in and of themselves, if I were only shown the injuries without any other information, one of them could have occurred an hour before, or, an hour more.
Along those lines, if you indicated that just being shown the injuries that you could reach the conclusion that he was potentially alive when these injuries were inflicted, are you able to tell if after these injuries were inflicted, he would be able to cough or move his tongue or anything like that before passing away?
I think, well, if he's dying, could he cough? I'd imagine so, yes. And if he had a terminal seizure, he might bite his tongue during that.
In regards to then, we've discussed now the cause of death. In regards to manner of death, we're able to form an opinion as to that.
Yes.
And what was your opinion?
And I like to always qualify this by saying that my opinion on the manner of death is for vital statistics and public health purposes. Our definitions of manner of death are not necessarily related to criminal proceedings, but in this case, my opinion of the manner of death is that this was a homicide.
And when you indicate that it's, for the purposes of vital statistics and that matter, what does homicide mean within that context?
That these were injuries inflicted by another, volitional injuries inflicted by another.
In regards to, and I think this is going to be the end of my questions for now, in regards to the injuries consistent with the strangulation, are you able to tell based on your training experience about how long a strangulation would last that leads to that type of injury?
Just through, not through personal experience, but training and reading and the literature, it's quite variable, but certainly more likely in the minutes, like very low minutes to multiple seconds. But when I say multiple, I mean more than 3. So it takes some time. If you simply eliminate blood flow to the brain, for example, and somebody passes out, if you immediately stop, the blood flow will resume and they will come to again. So it does take a period of time.
Thank you. Now, after going through the entire process that you indicated at the very beginning of your testimony, the standard procedure, did you conclude with authoring a report that summarized your findings and your opinions in this case?
Yes.
What I'm going to do is attempt to share my screen. I'm going to show you what's been stipulated to as People's Exhibit 1. Taking a look at that, does this appear to be the report that you authored for this case?
Yes.
Your Honor, at this time, I would move to admit the exhibit that's been stipulated as to People's Exhibit 1 into evidence. I have no further questions at this time of Dr. DeYoung.
All right, any objection to the admission as the exhibit?
No, Your Honor.
All right, I printed a copy, which we will put Exhibit 1 sticker on it. And so the report of Dr. DeYoung is admitted with its findings as People's Exhibit number 1. Ms. DeYoung, you're still under oath. This is an opportunity for defense counsel to ask you questions as well.
Thank you very much, Your Honor. Doctor, my name is Bill Weis. I represent Ethan Dingman. As I understand your testimony and your findings of asphyxia due to strangulation and the blunt force injuries to the head, and I certainly understand that obviously Mr. Schwarz was alive when he would suffer the asphyxia due to strangulation as well as the blunt force injury to the head. Are you able to specifically give us your opinion that it was in fact the blunt force injury to the head that was the specific cause of death?
No, it's a combination. I think that, you know, they're both listed there because, and the cause of death itself is listed as multiple injuries, including strangulation and blunt force. So I believe that they both contributed to the death.
If you were able to remove the asphyxia due to the injuries and the asphyxia due to strangulation, is it your opinion that Mr. Schwarz still would have suffered death?
He may have. It's potentially lethal, but it's sort of one of those hypotheticals that's a little bit difficult to answer. It was a serious injury. There was a bruise on the brain in addition to just the significant blood loss from this. But I don't know that he would have died from that.
Okay. Same question inverted. If you were to remove the blunt force injury from the head, would the asphyxiation due to strangulation in and of itself been enough to cause death?
That one I'm a little more confident. If assuming he dies, okay, that he is dead, you know, and that's all you had. I think so. I've seen significantly more deaths where we only have strangulation without this blunt force head injury as well, with very similar findings. But it's somewhat uncommon to simply see the scalp injury with the bruise on the brain, although not unheard of. It's more common to find a strangulation without the other findings.
I understand. The injuries to the head of the decedent, would that have been enough, in your opinion, to cause a loss of consciousness upon impact?
It may be.
Are you able to give us any range of probability with respect to that?
I don't know for certain because I don't treat living people. So if you had that scenario, how often is it that somebody has a cerebral contusion that isn't lethal, but they lose consciousness? I believe it would be more likely that you would lose some consciousness, but I don't know the frequency.
You also mentioned the temporal proximity between the asphyxia and the blunt force of the head, and I think you'll find it was potentially an hour, or maybe more accurate to say up to a possibility of up to an hour between those injuries occurring. Is that a fair characterization?
No, I mean, I think when I look at everything in totality, including, you know, we're given I'm provided from my investigator an investigative report and scene photos, and so when I look at everything in totality, it appears to me they most likely all occurred, you know, simultaneously or around the same time, but if I were only looking at the injuries and trying to determine a timing of them based on, say, degree of healing, for example, that's a very imprecise science to say, well, I'm going to take a look at this and look at it under the microscope and see how much healing is here and look at these other things. That's less precise. It could be gapped by hours, more than 1 hour.
Are you able to, can you walk me through the same analysis with respect to just kind of adding or blending in the the injury that you described on the front of the chest in terms of temporal proximity?
Yeah, so the injury on the front of the chest, actually, there were some bruises on the front of the chest. There was one of them that actually looked to be, and I'm going to refer to my notes a second just so I get this correct, but there was kind of also it was like more of a yellow abrasion or a yellow scrape on front of the chest, which kind of gives you the impression of something that occurred in the post-mortem period, or, you know, very shortly after death. But the bruises themselves, when we actually see these purple-blue contusions, those look to be something that occurred while alive. But so excluding the one that is more yellow, the scrape on the skin that has more of a yellow coloration to it, those bruises certainly could have occurred around the time in that perimortem period while these other injuries were being inflicted, or they could have occurred earlier by hours as well. And the dating of bruises is really a very difficult task and not something that's accurate whatsoever. So to look at them and say, well, I think these are 5 hours old and the other ones are 2 hours old, that's very imprecise and simply not possible.
And are you able to offer any information or opinion with respect to the time of death?
Time of death. It would take me a moment to look at that to try and sort out when was he last known alive, and when was he found dead? When did we know that Todd Schwarz was alive with certainty, and then when was he found dead? I'd have to sort of extrapolate from that. I'm looking through. By the time it's a little more complicated and not something that I really want to do on the fly.
Sure.
Yeah, you know, given the significance of my opinion here, I don't want to necessarily do that on the fly. You know, because there were some findings. Yeah.
Fair enough. So if I contact you with follow-up questions off the record as part of the investigation, that's something you'd be able to put together?
I would be able to, I could try. It would most likely be somewhat of a range, but I would certainly try with all the information and evaluations of how much rigor there was. And it's again, not a very precise science, but I don't want to just say something off the cuff here.
Absolutely. So walk me through quickly the factors in that analysis that you would take into consideration.
Well, I mean, when we're looking at a time of death determination, the first really most important points are when was this person last known to be alive with certainty through a text message, through something that we say we're confident he was alive at this point, and then when was he found dead, and if we're trying to narrow it from there, we may be able to narrow it a little bit, depending on how big of a space that is. If it's only 30 minutes, all I can say is he died somewhere in that 30 minutes. We wouldn't be able to narrow that at all. But if it's significantly more time, and we're looking at, when the first responders got there and they were checking him and they found that he, was in full rigor already, we may be able to narrow it somewhat.
Do environmental factors have like temperature have an impact on the degree of rigor?
Yes.
Okay, how so?
Well, it's a heat-driven process, and so if it's warmer, the rigor would develop more quickly. There are a lot of factors that might change how rapidly rigor mortis develops. Then that's just one of the factors. But if it's, so when it's a warm environment, it comes and goes more quickly, as opposed to a cool environment where it develops more slowly. So there are those types of factors as well.
Okay. With respect to the report that you authored, it looks like the decedent had amphetamines and/or fentanyl in his system. Is that fair to say?
he had methamphetamine and amphetamine in his blood, and his urine had presumptive positives. They didn't confirm that in the urine for amphetamines and fentanyl.
Presumptive positive, but it wasn't confirmed?
Correct.
And can that confirmation still be achieved, or is that something that is no longer?
This was from 2019, right? Probably not. And the urine, it wouldn't necessarily matter. Well, maybe it matters. I don't want to say what matters to you, but in the urine, we typically are more interested in what's in the blood at the time of death, because the urine could be, you know, if it had been in your system and now it's in the urine and you just haven't voided yet, but it's been hours, there may be some significance to that. Just to say that, yes, he used fentanyl.
And in part of your analysis, you on direct and in some of my questions, you referred to looking at photographs. Did you also review police reports and or talk to the investigators?
Yes.
Okay. And do you have any information based upon the totality of your work in this case that the victim was a intravenous drug user?
I don't recall that specifically. I guess, you know what, I know that he had a history of heroin use. I don't, I did know that I was told he had a history of heroin use, but I don't know that I was told how he administered that, because sometimes they snort it, sometimes they inject it. So so when I'm saying I'm not sure, it's like, I'm not sure if I was told it was intravenous.
Okay. But it sounds like that was something that was told to you as opposed to something that you discovered during the autopsy.
Right.
Okay. And do you have any, do you know the source of that information?
Well, mine came to me in the investigative report, and it was actually the investigator on this case was Caitlin Hirsch, and she wrote it in her report that Chief Brinkert stated that the decedent had a history of heroin use.
Okay.
All right, let me stop you for a minute. When you're talking about your investigator, you're talking about a medical examiner investigator rather than a police investigator?
Correct.
All right, could you spell her name for us?
Yes, her name is spelled Caitlin is the first name, and her last name is Hirsch, capital Hirsch.
Thank you.
Is the toxicology report something that is separate from your report and the work that you did in this case?
It is.
Okay.
It looks like it's a separate 4-page report.
Is that something that you consult prior to authoring your report?
Yes.
Thank you very much, Your Honor. I believe that's all I have for the doctor.
All right, anything further, Madam Prosecutor?
Just very briefly, Dr. DeYoung, in regards to the methamphetamine that was found in Mr. Schwartz's blood, did you determine that to be a cause of death for him?
It did not.
Thank you. I have nothing further, Your Honor.
All right, Dr. DeYoung, thank you for being here with us.
Thank you, Your Honor.
Virtually. I'm going to remove you from the queue and you can go back about your business.
All right. Thank you so much.
Thank you. All right, who's next?
We would call Trooper Elizabeth Burkhois.
Remember how to spell your name. Good afternoon, Trooper Burgos. Thank you for waiting. They're ready to call you as a witness, so I'm going to ask you if you would please raise your right hand. Do you swear or affirm any testimony you're about to give here will be true, to the best of your knowledge and belief?
Yes, I do.
Would you state your name and spell your last name for the record?
Elizabeth Burgoyes, Bourgeois.
Thank you.
Boyce, where do you work?
For the Michigan Department of State Police.
And what do you do for them?
I'm a trooper at the Marshall Post.
And were you working in that capacity on the morning of November 21, 2019?
Yes, I was.
And on that morning, were you dispatched to the village of Colon in St. Joseph County, state of Michigan?
Yes, I was.
And what were you dispatched for?
For a medical call.
And do you remember where it was you were dispatched to?
I believe it was 224 Blackstone.
And did you arrive at that address?
Yes, I did.
And what did you do when you arrived at that address?
I was approached. I had heard Chief Brinkert say over the radio he wasn't able to locate the person who made the call or the victim. I was approached by a young man from the direction of the Shell station and asked him if he was the caller.
And in regards to when you arrived on scene, do you know about how long it was after you were dispatched that you arrived?
Within minutes, I was pretty close.
And do you remember about what time that was?
I don't. I believe it was around 7 a.m., but I'm not sure the exact timing.
Now, this individual that you were approached by, did you come to know this individual's name?
Yes, ma'am.
And what was that person's name?
Ethan Dingman.
And is Mr. Dingman, or is Ethan Dingman someone you would recognize if you saw again?
Yes.
Do you see that individual on the Zoom screen today?
Yes, ma'am.
And could you identify that individual for the judge by what he's wearing?
He has on glasses and a green and white striped shirt.
Your Honor, may the record reflect the witness has identified the defendant.
It may.
What did Mr. Dingman say when you came in contact with him?
Initially, he didn't say anything. He just stared at me. I had to ask him several times if he was the caller. He eventually acknowledged he was the caller. I asked him where the victim was, and he pointed to a garage nearby.
And what, if anything, did you do when he did that?
I told him to wait by Chief Brinkert's patrol car while I went to assist Chief Brinkert with whatever was going on medically.
Now, when you first came in contact with Mr. Dingman, can you describe exactly where it was that you were and he was?
It was behind the Shell station. There's an alley that runs behind the residences and businesses there. I had pulled into the alleyway, so we were kind of right at the property line between the two.
Was there anyone else on scene besides Mr. Dingman when you arrived?
Just Chief Brinkert.
After speaking with Mr. Dingman and then going and making contact, I'm sorry, I just want to clarify, did you indicate that you made contact with Chief Brinkert at that point?
Yes, ma'am.
So did you enter the garage at that location at that point?
I entered the doorway of the garage.
And what, if anything, did you observe there?
I saw a white male laying on the floor. His legs and arms were straightened at his sides. His head looked like it was laying on a folded piece of cloth, like a pillow maybe. There was blood pooling around his head. I observed some blood footprints and what looked like to be splatter marks in blood.
And after this, were you put in charge of controlling the scene, who was going in and out for evidence purposes?
Yes, ma'am.
Thank you. I have no further questions of you. However, Mr. Weis may.
Mr. Weis?
Thank you, Your Honor. Officer, can you hear me okay, Trooper?
Yes, sir. Yes, sir.
Okay. My name is Bill Weis. I represent Mr. Dingman. So first thing I want to do is I want to make sure I've received any report you may have generated. I have a 2-page report, like it was dated on November 22nd, 2019. Is that the one and only report you generated in with respect to this investigation?
Yes, sir.
Okay. And since November 21st of 2019, have you performed any tasks pertaining to the investigation of this case?
No, sir.
You testified on direct that Mr. Dingman approached you. Were you in your squad car? Were you on foot?
I was in my squad car. The first time I saw Mr. Dingman was when I drove in front of the Shell station to turn to go to the alley behind. He was standing at the Shell station doors watching me. By the time I got out of my patrol car, he had approached where I was on foot.
Okay, and would you agree with me that the Shell station and the Schwarz property is they're literally, I mean, they're separated by mere feet. Would that be fair to say?
Correct.
And you described that you had to ask or interact verbally with Mr. Dingman several times. Do you remember how many times? And could you give us more detail on what those interactions between you and Mr. Dingman were?
I don't remember exactly how many times I asked him. I would say at least 2 to 3 times. Mr. Dingman had what I'd probably describe as like a 1,000-yard stare. He was kind of looking at me, but he didn't really seem like he was processing what I was saying to him.
So this wasn't a situation where environmental factors or distance would have impacted, in your opinion or your belief, his opinion to hear you.
Not at all. We were within feet of each other.
And so you and Chief Rinkert are the only 2 officers on the patrol car?
I'm sorry, sir. Your camera froze. Could you repeat the question?
Sure, yeah. Did you, when you arrived and you came into contact with Mr. Dingman, at that point in time, it was just you and Brinkert on scene?
That's correct.
You then directed Mr. Dingman to stand outside or nearby Chief Brinkert's patrol car?
Correct.
And where was Chief Brinkert's patrol car in relation to where you parked back in that alley?
It was directly in front of mine.
Okay. But did you advise Mr. Dingman that he was under arrest, or did you advise him specifically that he was not under arrest at this time?
I didn't advise him anything. I just asked him to wait there.
So he wasn't in handcuffs or anything of that nature?
No, he was not.
Did you tell him he was free to leave?
I did not.
Was he free to leave?
Yes.
Okay. But you specifically directed him and caused him to move and to remain outside of Chief Brinkert's patrol car.
At the time, I wasn't sure if he responded to or listened to my directive because I had already moved to locate the victim with Chief Brinkert. I asked him to stay at the patrol car, but I didn't notice at the time whether or not he listened to me.
Okay. Thank you very much, Trooper. I appreciate your time.
Yes, sir.
Thank you. You can go on about your, well, let me make sure. Ms. Shepard, do you have any questions for the trooper?
I do not. Thank you, Your Honor.
All right, thank you. Trooper, I'm going to release you from the feed here.
Thank you, sir.
Thank you. All right, Ms. Shepard, who do you have next?
We would call Chief Brinkert at this point.
All right. Chief Brinkert, good afternoon, sir. Would you please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Would you state your name and spell your last name for the record, please?
Mark A. Brinkert, Brinkert.
Chief
Thank
Brinkert,
you.
Chief Brinkert, where do you work?
I work for the Colon Police Department.
And what do you do there?
Currently, I am the chief of police.
And was that your role on November 21, 2019?
Yes, it was.
As chief of police, do you also conduct patrol and respond to calls for assistance for the Colon Police Department?
Yes, I do.
Right. And were you working on the morning of November 21, 2019?
Yes, I was.
And that morning, did you respond to 224 South Blackstone Avenue in Colon?
Yes, I was dispatched to a medical.
Right. And what's located at 224 South Blackstone?
It's a combination. The lower part is a hair salon, Illusions Hair Salon, and then the second floor is a residence.
And geographically, what is it located close to a Shell gas station?
Yes, it's right next to the Shell gas station. I think there's a fence that goes between the two, but it's only like 3 foot between the Shell building and 224 South Blackstone.
And were you familiar with the owner, the occupant of the property at 224 South Blackstone on November 21, 2019?
Yes,
And who was that?
Todd Schwarz.
And were you familiar with him just contacts in the community?
Contacts through the community. He had his nephew staying with him, and we had a truancy issue. And so I contacted Todd about that. But yeah, just in general.
Now, when you arrived at 224 South Blackstone Avenue, what, if anything, did you do?
They said it was in the garage, so I went around back into the alley. I had trouble locating an entry point. It took me a minute or two. Then I was able to open the walk-in door on the east side of the building, and that's when I saw the decedent.
When you say you saw the decedent, who was it that you saw there?
Todd Schwarz.
And did you recognize him right away?
I recognized him. It wasn't right away because of the color. But yeah, I recognized him as being Todd.
And did you check to see if Mr. Schwarz was responsive at that time?
I checked for a pulse on his left wrist, and he was cold to the touch, and I did not feel a pulse.
And about what time was this?
6:55 a.m. I believe I arrived on scene. I'd have to look at my report, maybe 6:52 a.m.
And after finding Mr. Schwarz inside of the garage, what, if anything, did you do next?
Trooper Weis came up and said the caller was outside. I asked her to secure the door, and I went and made contact with the caller.
And did you recognize the caller?
Yes.
All right. And who was the caller?
Ethan Dingman.
And was Ethan Dingman someone that you had had previous contact with before November 21, 2019?
Yes.
Would you recognize Mr. Dingman if you saw him again?
Yes.
And could you identify him for Judge Middleton by what he's wearing?
Sure. He's wearing the white and green striped uniform, black hair, glasses.
Your Honor, may the record reflect that the witness has identified the defendant.
It may.
And did you attempt to speak with Mr. Dingman when you came in contact with him?
Yeah, when I went back out to my car, he was standing near it, and I asked him, what was going on. And he was difficult to communicate with. It was, like he wasn't hearing me. Sometimes I had to repeat myself.
Did he indicate that he knew who was inside of the garage?
Yeah, as we talked, I asked him, I said, who is it that's in there? And he said it was Todd Schwarz.
And Did he indicate to you whether or not he had had contact with Mr. Schwarz while he was still alive that day?
He said, if I recall right, it had been a week since he saw Todd. So no, he did not have any contact, he told me, with Todd that morning until he found him.
And did you ask him if Mr. Schwarz had done anything to harm him or upset him that day?
Yeah, during my interview, I was talking to Ethan, and I asked him if he was upset with Todd. I knew that he had stayed with Todd previously, was no longer staying with Todd. And I just, hey, what happened? Did he do something? Did he make you angry in any way?
And did he respond to that question?
He said no, he was not angry with Todd.
Now, at this point in your conversation with Mr. Dingman, where had that been occurring?
Initially, we were outside my squad car. It began raining a little bit harder, so I had him sit in the front seat of my squad car, and I sat in the driver's seat as I spoke.
Now, at some point, did you leave Mr. Dingman after having a conversation with him in the patrol car?
Yeah, after my initial contact with Ethan, I needed to go back in and get some pictures before it swamped with people. So I asked Ethan to sit in the back seat of my car, which he did, and then I secured my car, making sure that people didn't have access to the driver's compartment and the computer system.
Now, at some point after that, did you come back to your car?
Yes.
And did you have any further contact with or ask Ethan any further questions then?
Your Honor, can I place an objection on the record here?
Yes.
And it's really more of logistics than an objection. I spoke with Ms. Shepard prior to the hearing. Your Honor, what I believe you're going to hear is testimony from Chief Brinkert about a number of individual interviews between Chief Brinkert and my client. What I would like to do, and I don't believe Ms. Shepard is going to object, is place an objection based upon custodial interrogation, preserve that so I don't have to continue to voir dire and interrupt Ms. Shepard during her examination of the chief, and then preserving it ongoing through my cross-examination of the chief and leaving the matter of admissibility of all of my client's statements up to the court at the conclusion of the chief's testimony, if that makes sense.
Any objection?
Not to that way of proceeding with things, Mr. Weis, and I did discuss that ahead of time, and we thought that would be the way to be most efficient with the court's time this afternoon.
All right, at this point, the defendant is removed from the front seat of the car to the back seat of the car. Now, I assume the difference there, Officer Brinkert, is that you can lock him in. Was he locked in the back of the car?
Yes, our squad cars are not equipped, so you can open them to prevent any type of escape or anything.
Like most police cars, you can't open the back seat from the inside.
Yes, sir.
Was he in handcuffs?
No, Your Honor.
Did he have access to the front seat of the car?
No, because there has been issues of people crawling through the security screen and driving off in police cars. I secured the sliding glass divider.
I remember a couple of those. Was he told he was under arrest?
No, he was not under arrest at that time.
He was not told he was under arrest, then as far as you're concerned, he was not.
No, sir.
Was he free to leave?
I'm going to say yes, if he would have said something. But since, we didn't cross that path, I can't.
All right,
Yeah,
so
he could have, At some point, yes, he probably would have been able to leave, but that never came up.
All right, Ms. Shepard, why don't you pick up from there?
Thank you. Now, at some point, did you return to your car in order to, this is after the first contact that you had with him. Did you come back to your car in order to type a search warrant for the premises?
Yes, I did.
And without going into specifics, were you engaging with conversation with Mr. Dingman at that point in your patrol car?
Yes, I was.
And then after that, did you leave the car again at some point?
Yes. He started getting numerous calls from potential witnesses. And so he was placed in the back of Deputy Bingman's or Corporal Bingman's squad car while I left the scene to go talk to people.
Now, at some point, did you have an opportunity to ask him about how far, if at all, he had gone into the garage that morning?
Yes, I did.
Do you remember when that was? Was it the first conversation you had with him or the second conversation or at some other time?
I believe it was the first conversation.
And what did he indicate to you?
If I remember correctly, without looking at my report, he said that he opened the door and saw Todd there. He might have took a step in to the garage area, and then he stepped back out. He didn't like what he saw.
Did you ask if he had touched Todd at all?
Yes, I did.
And what did he say?
He said no.
And then at some point, was Mr. Dingman transported to the St. Joseph County Sheriff's Department for a voluntary statement?
Yes.
Who did the transport?
I did.
Okay. Approximately what time did that happen?
Oh, let's see. My timeline's going to be tough. At about 8:45 a.m. is when I transported him to the Sheriff's Department.
Now, did you ever ask Mr. Dingman if he knew who had harmed Mr. Schwarz?
Not a direct question like that. I asked him who was mad at Todd, who would have hurt Todd this way. And he said he didn't know, that he doesn't believe anybody would hurt him that way.
Throughout the entire time that you were having contact with Mr. Dingman, did his demeanor change at all? Did it remain the same?
Pretty much remained the same, very low key. He was not excited. He talked in a low tone. At times it was hard to hear him or understand him.
Now, at some point, did you check Mr. Schwartz's house to see if it was locked?
Yes, I did. And the doors were locked.
At some point, were keys located for the house?
There were keys that were located in the yard between the rear of the house and the garage area.
And speaking of Mr. Schwarz, were you able to observe the condition of the clothing that he was wearing when he was there on the floor of the garage?
A quick note, yeah.
Okay, were you able to take note of whether or not the pockets of his clothes were inside or outside or anything else?
I believe the pockets were inside, but there was a large tear in the blue jeans he was wearing near the pocket area.
Now, in the course of your assisting or conducting the investigation for this case, did you come to find that Mr. Schwarz had worn a round pair of glasses?
Yes. In talking with his best friend, his brother, and his coworker, I showed them a photo of a pair of glasses, and all believed those were an old pair of glasses that he was currently wearing, square type glasses.
So I want to back up there a little bit. At some point, did you receive a photo from a family member of Mr. Schwarz wearing a particular pair of glasses?
Yes.
And would you recognize that photo if you saw it again?
Yes, I would.
All right. And what I'm going to do is attempt to share my screen. I'm going to show you what's been stipulated to as People's Exhibit 2. Do you recognize this photograph?
Yes, I do.
And is that the photograph that you received of Mr. Schwarz wearing these glasses in question?
Yes, it was.
Thank you.
Any objection?
Oh, yeah.
The photo looked like it was in front of a Christmas tree of the decedent wearing round glasses is admitted.
Thank you, Chief Brinker.
I'm sorry.
Thank you, Chief Brinker. I don't have any further questions for you at this point, but Mr. Weis will.
All right, thank you. You're still under oath.
Yes, sir.
Good afternoon, Chief.
Good afternoon.
So on the day of question here, you were wearing a body cam unit,
Yes, sir, I was.
and all of your interactions and activities that day have been captured on body cam footage.
Not all of my interactions, no.
Did you review the body cam footage that we do have prior to testifying in court this afternoon?
No, I did not. I reviewed my report.
Okay. So what time did you arrive on scene?
I'll go back to my report. It shows that I was dispatched at 6:51 a.m. and I arrived at 6:52 a.m. So I was a minute out.
Okay. And if I suggested to you that according to the body cam video, your initial interview of Mr. Dingman began at 6:55 and 24 seconds, would you have any reason to dispute that?
No, I have no reason. I don't believe I activated my body cam when I first got out of the car.
Sure, I've had it in jurisdictions where there's like technical glitches or something, and the time that shows up on footage might be an hour off or something of that nature. But
No, that sounds about right.
okay, so you would have been on scene for 5 minutes by the time you initially began, or so, before you began your initial conversation with
3
Mr.
minutes,
Dingman.
yeah.
3 minutes,
Yes, sir.
okay.
If it's 6:55.
Okay. And that video, if I were to suggest to you that that video ends at 7:22 and 56 seconds, any reason to dispute that?
No.
Okay. And that time would encapsulate the time when you had Ethan outside of your car and you had that first conversation with him, and then you left the car to go take crime scene photographs. Fair to say?
Right.
Okay. And during that time frame, as I understand your testimony on direct examination, you asked him if Mr. Schwarz had done anything to make him mad, and you asked him when the last time you saw him, and it was about a week ago. And then you asked him, do you know who did this? And Ethan said no. Does that basically summarize that conversation?
Yes, sir.
Okay. And the only thing really above and beyond that was an incredibly brief conversation about the light being on in the garage and Ethan having pushed open the door. Fair to say? Okay. And again, I mean, the video begins at 6:55. At 7:11 and 14 seconds, you had Mr. Dingman get in the rear seat of your patrol car. Any reason to dispute that?
No, I have no reason to dispute that, sir.
Okay, so we've got less than 5 minutes and we're going from the front of the seat to the back of the seat. And at that point in time, at 7:11:14, you asked Mr. Dingman to remove a pair of gloves he had been wearing.
Yes.
And at that point in time, Ethan was not wearing any eyeglasses, fair to say?
No, he had no glasses on.
Okay. And what happens next is you get out of your car, you leave Ethan in the car, and you go and you have a conversation with Super Bourgeois. I'm going to mispronounce her name.
Bourgeois.
Bourgeois. Fair to say?
Yeah.
And at that point in time, what you say to Trooper Bourgeois is, I got my guy. I'm not 110%, but I got my guy. Fair to say?
Not those words.
Not those words. What words would you use as your memory of that conversation?
I believe I said, I've got the suspect. I'm not 110% sure.
Okay. Okay. And at that point in time, Ethan is in the rear of your patrol vehicle as you go conduct an investigation.
As I took pictures, yes, sir.
Okay. And again, you've been on scene for essentially 20 minutes.
Okay.
Fair to say?
I will trust you.
Okay. Well, does that jive with your memory?
Yeah.
Okay. And during this initial conversation, would it also be fair to say that there were points in time when Ethan would volunteer random and bizarre, nonsensical statements? For example, out of the blue in that initial conversation, might say, you know, I haven't been able to talk to my mom in a long time.
Yes.
Okay. And did that cause you any concern with respect to Mr. Dingman's mental capacity?
It caused me concern as, was he under the influence of something? Was something going on? Did something traumatic just happen that he's acting this way? Yeah.
Okay, and you small town there, you had some, and I believe you've already testified that you knew Ethan to some extent, some degree prior to this morning?
Yes.
Knew he was kind of a homeless person who bounced from location to location?
I did not know he was homeless. I know he would go from place to place.
Okay.
That's it, something.
No.
Your
Give you
Honor,
You want me to mute that mic?
please.
If I mute it, it's difficult for him to unmute it, but I will do that. We might need assistance. Ethan, for your own protection, we're gonna mute your mic. And then if we need to talk to you, we'll ask the deputy to unmute it. Thank you.
So, Chief, after the first interaction with Mr. Dingman, is that when you typed the search warrant, or is that when you went and took photographs, or did you do both?
I went and took photographs of the scene at that time. When I returned to my car is when I started typing a search warrant.
Okay. And
Let me stop there for just a moment. This may not be clear, but you have a laptop computer in your car which is connected to networks, and you can use the word processor to type a search warrant and then email it or electronic fax it to the magistrate?
That is correct, Your Honor.
And is that what you were doing?
I was starting that process, yes.
Right from the laptop in your car?
Yes, Your Honor.
Okay.
Did you have anything else, Your Honor?
No, it's just a long time from when police officers used to knock on my door in the middle of the night to help with a search warrant. And we drive to the magistrate's house. Now everything's done electronically and there are laptops in the car.
Okay, so Chief, was your activities when you're taking the photographs, is that part of the time frame that your camera was not on?
My camera, I turned off, I believe, when I took the photograph.
Okay. Do you know how long you spent taking photographs?
Probably a minute. It was just a quick overview of the scene.
And I'm sorry, did you say a minute or 8 minutes?
1 minute.
Thank you. Okay. So then you come back to your car and Mr. Dingman is seated in the rear seat, yes?
Eventually, life care ambulance showed up on scene, the fire department showed up saying, so I had quick interaction with them before I got back to my squad car.
And by quick interaction, really what you said was, hey, no need, folks, you guys can go about your day.
Yes,
So then you went back to your car and Ethan is in the back seat. At that point in time, did you read the Miranda warnings to Mr. Dingman?
no, I did not.
Did you tell him he was free to leave at any time?
No, I did not.
Did you obtain any type of consent for him to make a voluntary statement?
Just the fact that I asked a question and he would answer.
Okay, but some officers have those consent checklist forms that they go through.
No, I did not.
Okay. And why the need to go back and continue the conversation with Mr. Dingman at that point in time?
Honestly, I was trying to find out why he was there. Why did he find Todd?
So you're specifically in your mind, is he in custody at that point in time?
No,
And why wouldn't he, you hesitated there. Why did we hesitate and why in your mind is he not in custody?
at that time, I was still conducting an investigation. I was interviewing Ethan. Yes, he was in custody because he was in the backseat of my car. Had he protested, we would have dealt with it at that time.
I heard, yes, he was in custody because he's in the backseat of my car.
Yes,
And to
sir.
be clear, he cannot get out of the backseat of your
No,
car.
sir.
Right. Okay, and earlier in the conversation here that I think the judge asked you if at some point in time would he have been free to leave. Your answer was probably at some point in time if he would have asked.
Yes.
Okay. Well, if Mr. Dingman says I'm gonna open up the car door here at this point in time, I'm gonna leave. Is it your testimony is that you would have allowed him to do that?
Speculation, yes,
Speculation.
because
Okay.
we never got to that point.
Okay, but he's in custody, and you moved him from the front seat to the back seat, and he can't open the back seat, and he's a suspect, and you clearly indicated at that point, at that time, at the end of that first conversation, you said, I have my suspect, I'm not 110% sure.
Yep.
All of this is fair to say, right? This is all accurate?
Yeah.
Okay, and then you go back to him specifically to interrogate him with respect to the events of that morning.
Ask questions, yes.
Okay. And that conversation lasts until about 7:41 and 22 seconds, fair to say?
Fair to say, without looking at the video and the timeline on there, yes.
And at that point in time, you again go and reconvene with the other investigating officers, fair to say?
To the officers arriving at the scene, yes.
And at that point in time, what you say to these other officers is, wow, Ethan isn't making any sense at all. Is that fair to say?
Yes.
And did you, and again, this is you and the officers talking, outside the presence of Mr. Dingman, did you have a conversation with the officers about the decedent in this case being homosexual?
Yes.
Did you have conversation about the decedent in this case possibly having sex with kids that he let stay there for room and board?
I don't believe I used the word kids.
Words to that effect.
To people, yes.
Okay. And then the medical examiners begin to show up and you say, okay, we don't need you. And then you go on to state in this meeting with officers that this suspect is really out of his mind or is just a dumbass. Fair to say?
I don't remember using those terms.
Okay, but would it be fair to say that that based upon your your statements after having very recently interacted with Mr. Dingman, that you were concerned about his mental capacity?
Yes.
And then at 7:43 and 49 seconds, you go back to the car again to talk to Ethan, right?
Could be, yes.
No reason to dispute that?
No.
Okay. And you begin to, and again, before questioning Mr. Dingman again, absolutely no Miranda warning.
I did not.
Absolutely no, you're free to leave.
Nope.
Absolutely no consent form or anything going over, getting his explicit agreement to discuss anything with you.
No.
And after your third interview, and by the way, in that third conversation, Mr. Dingman says, hey, I didn't have anything to do with this, correct?
That is correct.
And at that point in time, or no, you transported Ethan to the jail to be interviewed by Detective Sergeant Chad Spence and Detective Dave Males.
Yes, sir, I did.
I'm getting a signal across my computer, everyone, that my internet connection is maybe being disrupted. If you guys lose me, somebody get my attention, please. Chief.
Okay, it's been, we've had a glitch or two, but we're doing okay.
Okay.
We're gonna take a break here shortly. I think probably the defendant could use one, but go
Okay.
ahead.
And before you transported Ethan to the jail, did you advise him he was placed under arrest?
No, I told him we wanted to do a videotaped interview with him.
Okay. Did you, and then you took him to the jail and then that's when you passed him off to the other officers for continued interrogation?
For them to do their interview, yes, sir.
Okay. would it be fair to say that in the second interaction with Ethan and the third interaction with Ethan, he continued to make statements that were just completely nonsensical?
Yes, he made random statements.
And one of which was something about his dad having passed away in the alleyway.
Yes, sir.
After and other examples would be he was having something about, boy, when I was 18, that year went by really fast.
That's correct. He did state that.
Another random, nonsensical, bizarre statement. Ethan says, I'm a pretty good card player.
Yes, he did say that.
Okay. Subsequent to Ethan arriving at the sheriff's department, did you go back to the scene and do a search of the home?
I went back to the scene. I was not part of any of the searches. That was left to the St. Joe County Major Crime Task Force and the State Police Lab team.
Okay. And you've been able to hear the testimony, or you heard the testimony of Dr. DeYoung, where she indicated that she had some conversations with officers, and I believe she believed them to be you, that made statements as to Mr. Schwarz being a drug user. Did you make those statements?
I made a statement to Caitlin Hirsch, the MEI, that it was crack cocaine, not heroin.
Okay. And what did you base that statement on?
Nothing with evidence, just the rumor mill of a community that I've been in.
Fair to say, and I appreciate the candor of the answer. Same thing about pertaining to Mr. Schwarz and engaging in homosexual sex?
It was known that Todd was gay, yes.
Okay. And evidently, or eventually, there were a lot of drug components found on the person of Mr. Schwarz and within the home, within the Schwarz home?
Yes.
And it would have included pipes in his pockets to ingest methamphetamine?
I believe so, but I can't say 100% sure, but I believe so.
And we also had what was essentially a one-pot meth lab that was discovered in the home.
That is correct.
And all of this was done either while Ethan was being talked to at the jail and or after that point in time.
That is correct.
Fair to say. What follow-up with respect to your investigation did you yourself partake in? After you transported Ethan to the jail, what, if anything, did you do pertaining to this investigation?
I talked to other witnesses, people at the Shell station.
To your knowledge, was any physical evidence retrieved or located from the Shell station?
That I don't believe so. But again, I believe the State Police Laboratory team handled the Shell station.
Okay. Your Honor, if I can just have a moment to review my notes.
Certainly.
Your Honor, thank you. I have nothing further at this time.
Any redirect?
Very briefly, Chief Brinker, when you told Ethan that you wanted to take him to get a videotaped interview of him, how did he respond to that?
I believe, he didn't say no. He didn't say I didn't want to go. And so, I took it that he went willingly.
Thank you. I don't have any further questions.
All right, we're going to take a break. I'm going to stop the record. I'm going to leave the live feed on. So you've had trouble with the chat function. The clock doesn't work here. We'll take about a 10-minute recess and try to resume at 2:45. Mr. Dingman, I'm going to ask the officers to let you take a short break, and we will resume here in about 10 minutes.
Thank you, Your
Thank you,
Honor.
Your Honor.
The power went out here in the courthouse on Thursday for several hours, so all the clocks are all out of whack, but, and it's 2:36 by the computer clock. So we'll be back here in just a moment. Ms. Shepard, do you know who your next witness is?
Yes, it would be Deputy Hughes.
All right. Deputy Herman and Detective Males, I'll just give you an update. We took a brief break. I'm going to put you back in the waiting room. Don't go away. And Deputy Herman in the waiting room. Deputy Hughes, I'll leave you here on this side. Welcome back, Mr. Dingman. We're going to have that phenomenon again about 4 o'clock where the Zoom wants to shut off because we've been on for 9 hours. So we'll have to keep an eye on that. All right, it's 2:45. We took a very short break. I appreciate everybody's quick turnaround time. I will let you know I'm available all morning tomorrow if we need to continue this beyond this afternoon. The parties have rested their questioning of Chief Brinkert. I understand the next witness will be Deputy Joseph Hughes. All right, Deputy Hughes, could you please raise your right hand? Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
I'll let you know as well, we're live on YouTube, we're on the Zoom platform, and everything is being recorded. Ms. Shepard?
Thank
Oh,
you.
first of all, would you state your name and spell your last name for the record?
Deputy Joseph Hughes, Hughes.
Thank you.
Deputy Hughes, where do you work and what do you do there?
I work for the St. Joseph County Sheriff's Department, and I'm a deputy.
Were you working as a deputy on November 21, 2019?
Yes, I was.
And were you called into the Sheriff's Department's headquarters that morning?
Yes, I was.
And why were you called in?
To work with the Major Crime Scene Task Force.
Did you end up assisting with a homicide investigation that day?
Yes, ma'am.
And what was your role in assisting with the investigation?
To assist Detective Sergeant Spence with collecting the clothing from Ethan Dingman.
And did you make contact with Ethan Dingman that day?
Yes, I did.
Is he someone that you would recognize if you saw again?
Yes, I would.
And do you see him on the Zoom screen this afternoon?
All I see are you and I.
You have to slide to the right.
Live?
You're on a
Okay.
phone, apparently.
Are you able to manipulate the screen back and forth to see other participants in the
Yeah.
call? And do you see Mr. Dingman among the participants?
Yes, I do.
And could you tell the judge who he is by what he's wearing?
He's wearing green and white striped shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
That may.
Now, in coming in contact with Mr. Dingman in terms of this, what your role that day, where was he very cooperative with you?
At times, and at other times, no. So yes and no.
And did you end up documenting different things that day, such as taking photos of his clothing?
Yes, I did.
And did you also end up collecting his clothing that day?
Yes, I did.
And was that pursuant to a search warrant?
Yes.
And what did you do with the clothing once collected?
They were photographed and placed in evidence bag, labeled and entered into the system.
That clothing, oh, sorry, go ahead.
Actually, they were photographed, packaged, and then turned over to Colon Police Department. I believe they entered them into the system.
Now, among the items that you collected, did you collect a pair of shoes from Mr. Dingman?
Yes, I did.
Did you collect a pair of pants from his person
Yes, I did.
and a shirt that he was wearing?
Yes, I did.
And did you also document a pair of glasses
Yes.
and a banana?
Mm-hmm. Yes.
Okay. And you also end up taking swabs from Ethan?
Yes.
And what type of swabs were those?
They were sterile swabs with distilled water of his hands, and then buccal swabs of the inside of his mouth on both sides of his cheek.
Did you ultimately take the evidence that you collected and transport it to the Colon Police Department yourself?
Yes, I did. Well, to the scene where the crime scene was, and I turned it over where all the other evidence was.
Now, I'm going to share my screen in just a second here with what have been stipulated to as People's Exhibits 3 through 11. I guess I'll let you look at each one when you're done looking at it. If you could just say done, and we'll flip through them each that way, and then I'll have a question for you at the end of them. So if you could just look at them long enough to see if you understand what it is, and then we'll go through each one like that. Does that make sense?
Yes.
So this is what's been stipulated to as People's Exhibit 3.
Okay, done.
People's Exhibit 4.
Done.
People's Exhibit 5.
Done.
People's Exhibit 6.
Done.
People's Exhibit 7.
Done.
People's Exhibit 8.
Done.
People's Exhibit 9.
Done.
People's Exhibit 10.
Done.
People's Exhibit 11.
Done.
Did you recognize each of those exhibits?
Yes, I did.
And were those photographs that you took in the process of assisting with the investigation on November 21, 2019?
Yes, they were.
Your Honor, at this point, I would move to admit to those stipulated exhibits. I have no further questions for Deputy Hughes.
May they have been admitted?
Yes,
Mr.
sir.
Weise?
Okay.
All right,
Okay.
number 3 appears to be a photo of the defendant wearing some pants. You can see his socks. Number 4 is a photograph of a banana. Number 5 is a photograph of shoes. Number 6 is a photograph of the bottom of the shoes. Number 7 is one shoe. Number 8 is a pair of glasses. Number 9 is a pair of glasses. Number 10 is a photograph of some brown pants laid out on the ground. And number 11 is a plaid flannel shirt. Exhibits 3 through 11 are admitted. Thank you.
And I have no further questions for for Deputy Hughes.
All right. Mr. Weise, any questions?
Yes, thank you. Deputy Hughes, the items that we just went through, you collected those as an evidence technician?
Yes, sir.
And can you describe for us the training and experience you have with respect to collecting forensic evidence?
My training and experience.
Yeah,
I guess I don't understand what you're asking.
if you don't have,
Mr. Weise, we're kind of losing you a little bit. Well, are you a evidence technician for the Major Crimes Task Force?
Yes, I am.
All right. Did you receive any training to give that position?
Yes, I have.
All right. What is it?
Crime scene, evidence collection, and processing, photographing.
Is that a course?
It was a class that was put on up in Lansing, that the department sent us to.
Anything else?
Other than working on scenes, and we do training or attempt to do training through the months, but with the COVID, that's been kind of hard to do. But, you know, we do training with the other departments as far as, you know, fingerprinting, evidence packaging, photographing, scene processing. So we do training.
okay. And can you hear me now, okay?
Yes.
Okay. Can you describe the steps that you took in this case to ensure that you protected the integrity of the evidence or the items that you collected? For example, did you wear gloves? Was refrigeration used? Were any additives used? Any steps at all that you took to preserve the integrity and the materials that you collected?
The gloves were used. The clothing was taken off by Mr. Dingman, handed to me, and I placed them directly into the evidence bag. Once and the items were placed in their own bags. When I went to photograph them, I did lay a sheet of paper out and set them on there while I was photographing them, as to not collect anything on them. Then the items were placed back inside the bags and sealed.
Do you recall the sequence of the items that you went through? The shoes, then pants?
No, I do not recall the
Would you have
sequence.
used, I'm sorry, I didn't mean to interrupt. Do you know if you would have used a fresh sheet of paper that you described between each and every item?
That I don't recall. If I did, you normally would, to protect but I can't remember if that happened.
Okay. Do you recall if you put on a fresh pair of gloves in between each of the individual items as you dealt with them?
No, I did not put new gloves on.
Okay. And this was all done at the county jail down there?
At the sheriff's department.
Oh, sheriff's department, okay.
Yeah.
And who was it that put you in contact with Mr. Dingman? Was it Chad Spence, and or Dave Males?
Detective Spence, Detective Males was in the interview room with him.
So was this before those two named officers interviewed Mr. Dingman or after that interview?
That I do not know.
Were you present when Mr. Dingman first arrived
No, I was not.
at the sheriff's department? Was there a conversation between you and the other officers about Ethan having been placed under arrest?
I don't recall having any conversation about that.
Okay. And I don't believe, you correct me if I'm wrong, but it doesn't sound like you have any independent knowledge that your activities took place after their conversation with Mr. Dingman.
I don't know when they spoke to him. I was just, when I showed up, when Detective Spence told me to go ahead and start doing the process, that's when I began. I don't know if they had talked to him prior, or
Okay.
I'm assuming they did, but I have no knowledge of that. You would have to ask them.
Yep, absolutely. So what did you do with the items that you collected upon your securing them?
Can you repeat? You were broken.
The items after collecting them from Mr. Dingman and photographing them, where did you take them?
After they were packaged and sealed, I transported them over to the crime scene, to our crime scene trailer, and they were put with the rest of the evidence to be taken to the turned over to the Colon Police Department.
The crime scene trailer, where was that located?
At the crime scene,
So these items went back to the crime scene. Okay. And then did you stay with the items or what did you do next?
I stayed in the trailer until I was advised I could leave.
And eventually Chief Rickard or someone advised you that your services were no longer needed, and that concluded your participation in this investigation?
Correct.
And since that date and time, have you done anything else with respect to this case? Any other investigation?
With this case, no.
Thank you, sir.
Anything further, Ms. Shepard?
No, thank you, Your Honor.
All right, Deputy Hughes, thank you. I'm going to remove you from the feed. You're free to go.
All right, thank you.
Thank you. Losing my voice. I'm not even doing most of the talking here. Who's your next witness?
Deputy Daniel Herman.
All right. Good afternoon, Deputy Herman. Thank you for waiting for us. You've been here for 2 hours, but it's time to take your testimony. I'm going to ask you if you would please raise your right hand. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Would you state your name and spell your last name for the record, please?
Deputy Dan Herman, Herman.
Thank you.
Deputy Herman, where do you work and in what capacity?
I work for the St. Joseph County Sheriff's Department. I am a road patrol deputy.
And were you working as a road patrol deputy on November 21, 2019?
I was actually my day off, but I was employed as such on that day.
Did you end up getting called in to assist with an investigation that day?
I did.
And were you given a variety of tasks to assist with the investigation once you responded?
I was.
And was it 224 South Blackstone Avenue in Colon, Michigan that you were called into?
Yes.
Now, was one of the tasks that you were given that day to identify potential evidence inside of the home of Todd Schwarz?
Yes.
And was that is that what is located at 224 South Blackstone Avenue?
Yes.
And at some point, did you go into the kitchen of that residence?
Yes, I did.
And did you locate some bananas inside that residence?
Yes, I did.
All right. Where did you locate them?
They would have been on the kitchen counter.
And do you remember, what color they were, if they were fresh, ripe, overripe bananas?
I don't recall.
Now, do you remember whether or not you documented what those bananas looked like that day?
I did not document that.
You remember?
Or the freshness.
You remember taking photographs that day?
I did not personally take photographs. I believe Officer Watson took photographs.
Would looking at a photograph from the scene that day help refresh your recollection?
Yes.
I'm going to share my screen and show you what's been stipulated to as People's Exhibit 12. Right. Do you see the photograph there?
Yes.
And does it refresh your recollection?
Yes.
Does the photograph depict the bananas that you saw on scene that day?
Yes.
And would you say that fairly and accurately represents what you saw while you were there?
Yes.
Thank you. Your Honor, I have no further questions of Mr. Herman and would move to admit People's Exhibit 12 at this point.
No objection.
All right, Exhibit 12, which appeared to be a picture of a kitchen counter with a number of items, including some bananas, is admitted. All right, Deputy Herman, that was your reason to be here. I'll excuse you. Oh, wait a minute, I'm sorry.
Mr. Weis may have some cross-exam questions.
Oh, I'm sorry. I jumped the gun there. Thank you.
I'll be very quick, Deputy Herman. Thank you.
Oh, take as much time as you want. I just skipped a step.
I'm easy to pass over, Your Honor. So, Deputy Herman, you conducted a search of the residence on, is it Blackstone?
Yes.
Okay. And part of that search, you went up to what you knew as the decedent's bedroom.
Yes.
And within that bedroom, you either found and or seized 10 different pieces of evidence pertaining to drug use.
Yes.
Could you describe those real quick for us?
We located several methamphetamine pipes, as well as the actual product of methamphetamine. And then inside the closet, we located trash bags that were full of one-pot meth labs.
Actual working meth labs?
None of them, I don't believe any of them were active. I believe they were all old.
Okay. And at that point in time, the scene actually had to be cleared for safety reasons?
Yes.
And did you also find evidence of meth lab or meth use in the adjacent garage?
I believe they located pipes on the victim, but I don't believe there was any other
Okay.
evidence in the garage.
Okay. And did you also do a search of a church?
Of the exterior of a church, yes.
Okay. Was anything taken from that location? See?
Yes, there was several, like a trash bag and duffel bag full of clothing that was believed to belong to the suspect.
Can you do me a favor and yell at me? I'm having a hard time hearing you.
There was like a couple trash bags and like a duffel bag that were full of like clothing and items that were believed to belong to the suspect.
And this is a church that was allowing Mr. Dingman to stay there from time to time? Is that your understanding?
Yes, so they had like a covered porch that he would sleep under the roof of, and they allowed him to do that as long as there was no activities going on at the church.
Real quick, is this like a room? Is it enclosed? Is it
It's
literally
not
just
enclosed. It's open. Like you go up the stairs, and then it's covered with a roof, but it's before you enter the door of the church.
Okay. Okay. Thank you very much, officer. I appreciate your time.
Yes, sir.
All right, sorry about that. Anything further, Ms. Shepard?
No, thank you, Your Honor.
All right, Deputy Herman, I'll release you from the feed as well. The only one we have left is Detective Males. Is that who you wish next?
Yes, please.
Good afternoon, Detective Males. Thank you for your patience. They're ready to ask you some questions now under oath. Would you please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Would you state your name for the record and spell your last name?
Detective David Males, M-A-L-E-S.
Thank you.
Detective Mills, where do you work and what do you do there?
I work at the Sturgis Police Department and I am the detective.
And in the course of your employment as a detective, do you from time to time assist other departments with investigations in their jurisdictions?
I do.
On November 21, 2019, were you working as a detective for the Sturgis Police Department?
I was.
And on that day, were you called to assist with a potential homicide investigation in Colon, Michigan?
Yes.
And where did you respond to?
We responded to 224 South Blackstone Street in the village of Colon.
And was that on the day of November 21, 2019?
That's correct.
Did you assist with any of the investigation on scene that day?
No,
At some point, did you ultimately travel to the St. Joseph County Sheriff's Department to help with obtaining a statement?
I did, yes.
And who were you obtaining that statement from?
Ethan Dingman?
Mr. Dingman, someone you would recognize if you saw again?
Yes,
Do you see multiple people on the Zoom screen right now?
I do.
All right. Do you see if Mr. Dingman is one of the individuals on the Zoom screen?
He is. He's wearing green and white striped shirt.
Your Honor, if the record reflect that the witness identified the defendant.
It may.
Thank you. Now, while still on scene at 224 South Blackstone, was Mr. Dingman there?
He was in the backseat of a patrol car.
And in terms of him being transported to the St. Joseph County Sheriff's Department, did you believe that he was doing that voluntarily?
Yes.
And what led you to believe that?
I was told that he wanted to give a voluntary statement.
Now, were you present for the entire interview at the Sheriff's Department?
I was.
And in the course of that interview, was he asked whether he attempted to help Mr. Schwarz when he found him inside the garage?
Yes, he was.
And how did he respond?
He stated,
Just a minute. What room was this interview conducted in?
in the interview room at the St. Joe County Sheriff's Department.
Who was present?
Myself and Detective Chad Spence.
And Mr. Dingman?
Yes, that's correct, Your Honor.
Was it recorded?
It was recorded.
Before you began this questioning, was the defendant advised of his Miranda rights?
Not at the start of our interview, he was not. My understanding was that he was a witness and that he was giving a voluntary statement.
Your understanding from who?
From Chief Brinkert and the officers on scene.
Where did they tell you that?
I stated that Ethan had made the 911.
No, where did they tell you that?
Oh, on scene in Colon.
All right, was the defendant taken back to the sheriff's department in Officer Brinkert's patrol car?
I believe so, yes.
Did he come in through the front door or did he come in through the Sally Port door at the jail?
I do not know. By the time I arrived, he was already inside.
Now, the St. Joe County Sheriff's Department is divided into two halves. There's the jail half and the administrative half. Which side of the building were you in?
The administrative portion.
So there were no bars or steel doors or that sort of thing?
That's correct.
But the doors are locked, are they not?
The door to the interview room is not locked from the inside or outside. And on the administrative side, once you're inside of the building, you can freely get out.
All right, thank you. They're locked to get in, but unlocked to get out?
Correct.
All right, I'm sorry. So you and Officer or Detective Spence sit down with him What time is this?
I arrived on scene about 8:15, I would say 9:30-ish. I don't recall the exact time frame.
All right, thank you. You may proceed with questions, Ms. Shepard.
Thank you. Detective Mills, did you question Ethan as to whether he attempted to help Mr. Schwarz?
Yes, we did.
And what did he say?
He stated he did not render any aid to Mr. Schwartz, that there was a lot of blood and he didn't want to touch it.
Now, did you ask him why he called 911 from a Shell gas station?
Yes, we did.
And what did he indicate?
He said that his phone did not have any power.
And when you say his phone, would that be like a cellular phone?
Correct, yes.
What was his demeanor during the course of the interview with you and Sergeant Detective Spence?
It ranged from non-emotional, very flat, to very agitated and aggressive towards myself and Detective Sergeant Spence.
In the course of having this conversation with you, did he indicate what position Mr. Schwartz was in when he came in, when Mr. Dingman entered the garage?
It depends on which version of his story we talk about. The first time he told us that when he found Mr. Schwartz, he was on his side.
So did his version of events change over the course of your interview with him?
Yes, it did, approximately 4 times.
Now, at some point during the interview, did he ask to contact his attorney?
He did, yes.
And did you offer assistance in having him contact his attorney?
We did, yes.
Yeah, and how was that assistance offered?
I told Mr. Dingman that if he had his attorney's phone number, that we would be more than happy to contact him. He told us that it was in his cell phone. He did give me consent to look in the cell phone. I turned it on, it powered on fine. Mr. Dingman gave me the passcode to get into his phone, which was a design. We then looked through the phone contacts for his attorney, who he stated the name was Kill Bill, for a few minutes. And then Mr. Dingman decided that the attorney's phone number was not in the phone. So it was then turned back off.
So was at the time that then you were attempting to assist him, there's still battery on the phone?
Yes.
Now, during the course or at some point, and perhaps you can help provide us information as to when, did items from Mr. Dingman's person end up on a table in the interview room?
They did.
When in the course of the interview did that occur?
At the beginning of the interview, Detective Sergeant Spence asked Mr. Dingman to empty the contents of his pockets out onto the table.
And among the contents that were emptied onto the table, was there a banana?
There was.
And was there a pair of glasses?
Yes.
Now, during the interview, were you able to observe the clothing that Mr. Dingman was wearing?
I did.
And was there something that you took note of during the course of the interview that drew your attention about his clothing?
Yes, it appeared that some of his clothing did have what could be described as blood staining.
Do you remember what item of clothing or item particularly drew your attention?
The beanie winter cap that he had on had what appeared to be a larger red stain on it. Also, his tennis shoes appeared to have blood splatter. Also, his hands and some of the items which he set on the desk.
Were the glasses among those items that
Yes,
appeared to have blood on them?
Yes.
Thank you. I have no further questions for you at this time, but Mr. Weis may.
Thank you. Detective Mail, can you hear me okay?
You're a little muffled, but I can, yes.
Is this any better?
That's better.
First of all, was this interview of Ethan, that constitute your entire participation of the investigation in this case?
Yes,
And you wrote a 6-page report. Looks like it was dictated on 11/21, printed on December 5th of 2019. Would that be the only report that you generated in this case?
that would be correct, yes.
Okay. And so the genesis of your involvement in this situation was you were called by Chief Brinker along with Detective Sergeant Spence for the purpose of talking with Mr. Dingman.
Correct. The Major Crime Task Force was activated, and being a detective, I'm part of that. And so the investigators were called out to assist Pullman Police Department.
Okay. And so when you arrive, you have a conversation with Chief Brinker? Is that the first thing that happens?
Yeah, it was myself, Chief Brinker, Detective Sergeant Spence. I believe Trooper Boyce was there, just to kind of get an idea of what was happening and what the crime scene appeared to look like, what the nature of the call was.
And how long were you at the crime scene before you left to go back to the administrative building for the purpose of this conversation?
I can't give you an exact time frame. I would say half an hour to 45 minutes.
Okay.
It wasn't an extended period of time.
Sure. Okay. And based upon this meeting of the minds at the crime scene, if I understand your testimony, it was decided that Mr. Dingman was going to be transported to the sheriff facility for a voluntary statement. That's correct?
That's correct.
And you used the word witness on direct examination. Is that correct?
That's correct.
And so in your mind, you're under oath here, and you're telling us that at that point in time, Ethan Dingman is merely a witness to you and not a suspect in any way, shape, or form.
I can tell you at that point in time, any evidence that we may have would not lead us to believe, we would not be able to prove that he is a suspect. So therefore, he starts out as a witness, correct?
And that was communicated to you specifically by Chief Brinker.
What was communicated to me?
That we don't have, because you've been there for less than a half hour, and he's been there all morning, and you guys are having this meeting, and Chief Brinker says, hey, look, we got this Ethan Dingman guy, he called 911, but we don't have any evidence to arrest him. We don't have, probable cause to make an arrest. He's just a witness. Why don't you guys go take him down for a voluntary statement? Is that the conversation you had with Chief Brinker before you took Ethan Dingman to the sheriff's department?
Pretty much.
Okay. If you had to change it by adding something to it or taking something out of it, what would you add or take out?
Take out of what?
My synopsis of the conversation that I just walked through.
Well, we did look at the crime scene. We did see the victim laying on the floor. Ethan Dingman was the only person there. He was the 911 caller. He approached the trooper. At that point, we did not have anyone else to talk to or anyone else who we believe to be involved, either as a witness or as a suspect.
So if Chief Brinker has already indicated under oath here today that at the onset or early on in the stages of his interaction at the scene, he was getting calls from a number of victims, or I'm sorry, a number of witnesses. That was something that was not discussed during this meeting at the scene that you participated in?
Initially, no. My initial, when we arrived, Ethan Dingman was the person there. Whether or not Chief Brinker received calls from other witnesses after we left, it is unknown to me.
Well, yeah, I'm focusing on what Chief Brinker expressed to you at this initial meeting, not anything after. I'm talking about your time, your mental state when you
Just
left
a
the
moment.
scene.
Mr. Dingman, can you hear us? Okay, good. All right, go ahead.
So please answer in that context.
Yes, when I arrived, Ethan Dingman was in the rear seat of the patrol car. We went through the crime scene. We left and went to the sheriff's department to interview him. I was under the impression he was giving a voluntary statement.
That's helpful, and that's what you did. I'm probing an area of what Brinker expressed to you in that briefing when you arrived on scene. Did Brinker advise you that there were a number of other witnesses that were going to need to be interviewed? Yes or no?
I don't recall that, no.
Did Brinker advise you that there were a number of other witnesses who had called him throughout the morning? Yes or no?
I don't recall that.
Okay. And did Brinker tell you that after his first 15 minutes or less conversation with Mr. Dingman, he had his guy, or he had his suspect, he just wasn't 110%? Did he say anything along those lines?
I don't recall him making that statement to me, no.
Okay. And so who was it that made the decision or the determination that Mr. Dingman wanted to go make a voluntary statement to you?
That's what I was told. I'm assuming Mr.
Right,
Dingman says it was a
by who?
voluntary statement
My question was by who?
by Chief Brinker.
So Brinker decides that Dingman wants to make a voluntary statement, and he conveys that to you.
He conveyed that to me. Who decided that he wanted to make a voluntary statement? Voluntary statement would tell me that Ethan Dingman decided that.
So you're guessing that Ethan Dingman said to Brinker, I want to go make a voluntary statement.
That's what voluntary statement is to me, yes.
But you're guessing that's what Dingman told Brinker.
That's what I was told.
You were told by Brinker that Dingman specifically told him he wanted to go make a voluntary statement.
I was told by Chief Brinker that Ethan Dingman was going to be interviewed. I was told that it was a voluntary statement.
Okay. And so did you ask Brinker if Ethan Dingman gave consent to be taken to the sheriff's department and gave consent to give a voluntary statement?
I did not ask him that, no.
Did you ask Dingman those questions?
No, when we arrived in the interview room, Ethan Dingman did not express any desire to leave. And at the point at which he did, we attempted to locate his lawyer for him.
We're going to get to your helpfulness in searching the phone in a minute. But prior to that, when you arrive at the sheriff's department, it's you and Spence, and you take Ethan into this interview room, yes?
Correct. Myself, Detective Sergeant Spence, and Ethan Dingman were in the interview room.
Okay. And in your mind frame, or did you know throughout the morning if Ethan had been given any food, given any water, had an opportunity to use the bathroom facility?
I do not know. I did not know.
Didn't make any inquiries along those lines?
He did not make any statements and he needed any of that.
That's helpful, sir. My question was to you. Did you make any inquiries along those lines?
I did not.
Okay. And did you have any information about his education level?
No.
His history or experience in dealing with the police or law enforcement?
No. This was the first time I've ever met Mr. Dingman was that morning.
Did you make any inquiries prior to having this conversation with Mr. Dingman?
No.
Okay. And you certainly didn't read Mr. Dingman his Miranda warnings.
Correct. It was a voluntary statement.
Right. And you didn't tell him he was free to leave.
I did not know.
No reason to, right? Because it's a voluntary statement, right?
Correct.
Okay. And he's just a witness, right?
Correct. At that point, he was a witness.
And this is what Brinker had told you, right?
Correct.
Okay. And Dingman never expressed any of those things to you, did he?
That he wanted to leave or needed something to drink or to use the restroom? No.
Or that he wanted to talk to you voluntarily or consented to the conversation?
He did not make that statement one way or the other, no.
How long did the interview take place?
The interview, refer to my notes, started at the interview ended approximately 1:30-ish, and probably started 9:30, 10 o'clock. I don't have the exact time for you.
And was Mr. Dingman placed under arrest immediately at the conclusion of the interview?
He was not.
How much time lapsed between, when was Mr. Dingman placed under arrest?
The information which we gathered from the interview was provided to the St. Joseph County prosecutor. The St. Joseph County prosecutor then decided that we had enough probable cause to place Ethan Dingman under arrest. At that point, he was advised he was being placed under arrest.
At what time was that?
1:30,
13:29?
correct.
And what time did the interview end?
So, a few minutes before that, long enough to have a conversation. As I told you, I don't recall and I don't have the exact time.
More than 5?
I would estimate around 5 minutes.
5 minutes. Okay. So at the conclusion of the interview, you call the prosecutor's office, have a very short conversation. You place Mr. Dingman under arrest. Fair to say?
No, the prosecutor was at the St. Joseph County Sheriff's Department.
Okay, so you had an in-person conversation, then you placed Mr. Dingman under arrest. Fair to say?
Correct, yes,
And then and only then is Mr. Dingman read his Miranda warning.
correct.
And there's audio recording of this interview, yes?
There's video recording of the interview. Once the interview was concluded, Detective Sergeant Spence attempted to burn the interview to a DVD. That is when he discovered that there were some technical issues with the audio recording inside of the room.
What technical issues existed inside of the room?
I do not know. It is not my interview room. It's at the Sheriff's Department. That is just what I was told.
Just to clarify, the prosecuting attorney at that time was John McDonough, is that correct?
That's correct, Your Honor.
And that's part of why we have a special prosecutor here today. We have a new prosecutor, Mr. David Marvin, and this would have been of the previous administration, as I understand. Is that correct?
That's correct.
Okay.
And is it fair to say during your conversation with Mr. Dingman, his mood would change greatly?
Yes,
His physical demeanor and mannerisms would change greatly
yes,
from peaceful to combative,
yes,
from cooperative to uncooperative?
yes,
Fair to say that these changes were random or appeared to be random to you?
yes,
Fair to say he made a number of statements that did not make any logical sense to you?
yes,
fair to say that Ethan would also go off on tangents that were completely unrelated to any question that you posed to him?
Yes.
Let's talk about Bill Kill Bill, the lawyer. So at some point in the questioning, Mr. Dingman says, I want a lawyer.
Yes.
How far into the questioning did he make that comment?
Towards the end.
And you informed Ethan that you would be happy to contact his attorney for him, right?
Correct.
And Ethan had a cell phone, right?
Correct.
Was the cell phone seized or in your possession at the time of Mr. Dingman wanting to speak to his attorney, or was the cell phone still in his possession?
The cell phone was sitting next to him on the desk.
So instead of just saying, Mr. Dingman, I'm going to step out of the room here to allow you to make a phone call, to call your attorney, what is it that you did to help this witness locate his attorney?
I told him that I would look through his contacts for the number so we could call his attorney.
You told him that.
Told him that I could assist him with finding his attorney's number by looking through the contacts. Yes.
Why wouldn't you just allow him to do so, sir?
I don't know. I just didn't.
Well, the answer is you wanted to flip through his cell phone and take a look in his cell phone. Isn't that correct?
That's not correct. We would get a search warrant for that.
You would need a search warrant for that. But if you're just helping him find an attorney, you don't need a search warrant.
He gave me consent.
What was the wording of his consent?
I don't recall the exact wording.
Did you use one of those consent forms or have him sign off on a consent form?
No.
Why would you need a search warrant if you offered consent?
Consent was merely to find his attorney's phone number. Was not for any further search through the phone.
At the beginning of the interview, my understanding, you had Mr. Dingman empty his pocket.
Correct. Detective Sergeant Spence did.
What was the purpose of that?
It's just standard operating procedure in most departments.
The standard operating procedure of you and your department before conducting a voluntary statement with the witness to have them empty their pockets?
Depends on what type of crime. Yes.
And that would be a written procedure in your training manual?
Would be a common sense procedure.
Common sense procedure? Well, you knew that Mr. Dingman had been secured in Chief Brinkert's patrol car for a couple of hours prior to being, and you also knew that Brinkert transported him to the jail, right? Or to the facility, the administrative side of the facility, right?
Correct.
You knew he had been in the custody and control of law enforcement for a couple of hours, and included having been transported in one of their cars before you dealt with him, correct?
Correct.
Didn't common sense lead you to believe that any necessary protective measures would have been taken up to that point? I mean,
I don't like to assume that things have been done that I have not witnessed.
well, that's
Just
not
when it
true
comes to
now,
something
sir,
like
is
that.
it? That's not true now, sir, because you certainly assume that Mr. Dingman gave a voluntary, he was here to voluntarily speak with me. I'm not gonna check out anything with respect to his mental state, education, history, don't care, doesn't matter to me. Chief Brinker says he's here to talk voluntarily. I'm assuming he made this statement, he's here to talk voluntarily. Isn't that what you testified to about 10, 15 minutes ago?
I testified that Chief Brinker said he wanted to give a voluntary statement.
Didn't you say that you assumed that Dingman must have said that to him then, to Brinker?
Correct.
Well, so it's safe to assume things when they fit your needs, i.e., we don't need to read this gentleman his Miranda warnings, but yet it's also fair for you to make assumptions the other way when maybe we want to do a search without a search warrant or going through Miranda warnings. Isn't that what's going on here, Detective?
No.
Explain it to me then. What's the difference between those? What's the difference in those two scenarios?
I don't understand your question.
Yeah. So you made assumptions that Ethan is there to make a voluntary statement. You based those assumptions on Brinker's statement to you. Yes?
Chief Brinker told me that, yes.
Yes. Is that a yes?
Chief Brinker made that statement to me, yes.
Okay. And you made the assumption then that it was true.
I know Chief Brinker, yes. I do not know him as someone who would tell me something that is not true.
Okay. So you were safe in making the assumption that you didn't need to Mirandize Mr. Dingman based upon the statements of Chief Brinker. Yes?
Based on his statements that Ethan Dingman was giving a voluntary statement, yes, I did not feel that we needed to Mirandize him.
Right. Okay. So that's an apple. Now the orange. You got a witness that's been in the care and control and custody of Brinkert for a couple of hours, transported from a scene to your location by Brinkert himself. And what is it that you do with this witness? You have him empty his pockets. And why? You just testified because you don't make assumptions. So justify those two things for me, sir.
Because no one told me that they had searched his person or if he had any weapons on him, and I did not see anyone check him for weapons.
Did you ask Brinkert if those things had been done?
I did not.
During your initial meeting with Chief Brinkert, did he give you reason to be concerned about the mental health of Mr. Dingman?
Yeah, he did. He stated that Mr. Dingman, he has known him in the past. I don't recall his exact statement. I don't recall his exact statement.
Thank you, Your Honor. I have nothing further at this time.
Anything further, Ms. Shepard?
Oh, thank you, Your Honor.
All right, Detective Mills, do you wish to stay or wish me to release you?
I'll stay.
All right, I'll mute your mic. Thanks.
Thank you.
Ms. Shepard?
Thank you, Your Honor. At this time, the people have no further witnesses. What we would do, though, is move to admit the two reports that have also been stipulated to by the parties, the People's Exhibit 13 and People's Exhibit 14. People's Exhibit 13 is Michigan State Police Laboratory Report, numbered Lab Report number 3. Then People's Exhibit 14 is also Michigan State Police Lab Report, report number 5. Those are both admissible pursuant to MCL 766.11B for the purposes of preliminary examination.
I understand there's no objection at any rate, but there is a special rule, Mr. Dingman, for preliminary examination where laboratory reports can be admitted just for preliminary examination purposes without further foundation other than the report. So under that rule, which she cited, 766.11B, I will admit exhibit number 13 which is dated December 4th, 2019. And it's by Paul Donald, forensic scientist of the biology unit. And it's date completed March 9th, 2020. Exhibit number 5 is a report dated December 4th, 2019, completed May 26th, 2020. It's by Michelle Schmidt, M-I-C-H-E-L-L-E-S-C-H-M-I-T-T, a forensic scientist at the biology unit at the Michigan State Police Crime Laboratory. So 13 and 14 are admitted. Anything further?
No, we have no further witnesses. The people rest at this time. Thank you, Your Honor.
Mr. Weis?
No proofs, Your Honor. Thank you.
Motion and argument?
Thank you, Your Honor. At this time, the people do move for bind over for the sole charge listed in the complaint in this matter for open murder. As the court is well aware, the people's burden during a preliminary examination is to provide that there's probable cause that the crime occurred and probable cause that the defendant is the individual who committed that crime. Starting with that first portion, probable cause that a crime occurred, it is the people's responsibility to show that Mr. Schwartz's death was caused by another, that the offender intended to kill, cause great bodily harm, or knowingly created a very high risk of death or great bodily harm through their actions. And we do have evidence through that. We had the testimony of Dr. Joyce D regarding the nature of the injuries in this case. She indicated that they were blunt force injuries as well as injuries consistent with strangulation. She described the injury with the laceration to the back of the head, which would have been a forceful impact against something, perhaps from a fall, perhaps from being pushed down, with then the front of his brain being bruised as a result of the force of that impact to the back of the head, it traveling forward to the front of the head. The petechiae that were present in the mucous membranes of his eyes, of his mouth, on his face, as well as the ligature marks that were present on his neck for the purpose of the strangulation. She said that the petechiae in particular, while they can present as the result of many different things that cause high levels of pressure, that strangulation is one of these things that cause a high amount of pressure. And knowing the type of force or impact, the reasonable inference from that would be that a person would be doing this intentionally or knowingly create a very high risk of either death or great bodily harm in order to inflict those type of injuries. Additionally, we have this is the evidence that goes towards the fact that this death was a death that does meet the elements of the open murder in this case. Now, the question that really I think before the court is there probable cause that Mr. Dingman is the individual who's responsible for this? Dr. DeYoung's testimony was that where this laceration was, that there's a profuse amount of blood vessels there that can cause a significant amount of bleeding. The testimony we have from various witnesses that Mr. Schwarz was found in a pool of blood in the garage at his location, and that in addition to that pool of blood, there were also foot marks left in the pool of blood. We have, based on the interview with Detective Males, as well as the Detective Sergeant who was present with him but did not testify today, but Detective Males indicated that he observed on Mr. Dingman that there was blood on the glasses that were set on the table, as well as on the footwear that he was wearing, which are the court can view in People's Exhibit 5, Exhibit 6, and Exhibit 7. There's blood on the other side, underside of the shoe, on the shoelaces present there. In addition to that, there's blood present in People's Exhibit 8 on the eyewear. That's in People's Exhibits 8 and 9 of the glasses that were located that we had then later testimony appeared to be similar to the glasses that were worn by the victim, Mr. Schwarz, in People's Exhibit number 2. On People's Exhibit 10, the pants that Mr. Dingman was wearing, there is clear some sort of staining on those clothes that are visible to the naked eye. And ultimately, these items were sent to the Michigan State Police Forensic Laboratory for evaluation. Each of these items were evaluated for the possibility of there being some sort of DNA evidence on them. Each of them were identified as items that potentially did have DNA items on them, and which was indicated in People's Exhibit 13. People's Exhibit 14 then does go on to show that these items that Mr. Dingman was either wearing or had in his possession did, in fact, there's a very strong likelihood or very strong support for the finding that Mr. Schwartz's DNA is on them. So Mr. Schwartz's DNA is found on Mr. Dingman's pants, on the shoes that he's wearing, on the shirt that he's wearing, on the glasses that were found on his person. Additionally, we had testimony that the house was locked, that keys were found outside of the house, but that when they did a search of the inside of the house, there were some yellow bananas that were located there. Also located on Mr. Dingman's person was a similar type of yellow banana. Those are visible in People's Exhibit 12, are the bananas that were located in the house, as well as in People's Exhibit, bear with me, Exhibit 4, the banana that was found on Mr. Dingman's person, or that he left there on the table while in the course of this investigation. All of these circumstances, in addition to the fact that Mr. Dingman was the only person who was found on scene when the police first arrived, they arrived within a minute of being dispatched to this call that was made from the Shell gas station. He was the only person who was there on scene. He also then was telling detective stories that continued to change, and that also were later found to be not true. He told Detective Nails, as well as the other detective who was present with him, that he had not, as well as Chief Brinkert, that he had not gone to Todd Schwarz, that he had not touched him, that he hadn't gotten close to them, he didn't render aid, there was no, he didn't have contact with him.
Stop. I'm not sure that's an evidence. Did Detective Nails testify to that?
That Mr. Dingman did not render aid? Yes, I believe he did. I believe that it was right after Mr. Weis made an objection or wanted to clarify something, and then I had to go back and re-ask Mr. Mills a question, or Detective Mills a question.
Asked if he attempted to help Schwarz, was a lot of blood and he did not want to touch it. Said his cell phone had no power. All right, so he makes an exculpatory statement. All right. I have some sincere reservations about the voluntariness of any statements made by Mr. Dingman at the Sheriff's Department, but we'll get to that. All right, I'll allow you to continue.
Thank you. In addition to the statements made at the Sheriff's Department, we also did have the statements that Chief Brinkert indicated that Mr. Dingman made to him, that he did not go in more than a step or two, and again, that he didn't touch anything, he had no contact or anything. We know this simply is not true based on the evidence that then was obtained from his clothing, the fact that he is covered in Mr. Schwartz's DNA, that he in fact was there in a place that was profuse with the blood of Mr. Schwarz because of the injury that was present in the back of his head, this injury that was intentionally inflicted, that was one of the causes of his ultimate death. So for all of these reasons, when you take the totality of these things into consideration, we do believe that people have met their burden of proof that there is probable cause that Mr. Dingman was responsible for the death of Mr. Schwarz. And so for those reasons, we do ask that you bind this matter over to circuit court. Thank you.
What do you mean when you say it was covered with Mr. Schwartz's DNA?
So when we go to the Michigan State Police Laboratory reports, first of all, in report 3, it indicates what they were looking for to see if there was any possibility for DNA testing to come back. And so, for example, the pants, it says that there's apparent stains noted after visual examination. We can also see that from the photographs that are present. In regards to if we go a little bit further down, the glasses that had been emptied from his pockets, they indicate the possible presence of blood. That's also visible in the photographs that the people have admitted. And then also this hemostix of the shirt indicate the possible presence of blood. Again, that I don't believe that the photos make it visually evident, but the testing that was done at the Michigan State Lab report indicated that there was a possible presence of blood on this. And then we also have Mr. Dingman's buccal swabs that were taken by Deputy Hughes during the course of the investigation. When we switch then to the Michigan State Police Lab Report 5, People's Exhibit 14, we then find out the result of that DNA testing. So the hypothesis when it came into the shoe swab, or the ultimate conclusion from the shoe swab, is that the analysis provided very strong support that Todd Schwarz is the contributor to the DNA profile developed from the shoe swab. These are the shoes that Mr. Dingman was wearing that from just the eye looking at it appeared to have blood on it, that the testing that MSP did in lab report 3 indicated there was potentially blood on it. And in fact, it was there. And again, the officers testified that while on scene, they did see what appeared to be shoe impressions in this area where there had been blood in the garage as well. This puts Mr. Dingman at the scene then in the presence of Mr. Schwarz when he's there, profusely bleeding from his head from these inflicted wounds. Similarly, the pants that were tested in the next line, it provides, there's a mix of the DNA there. It provides very strong support that Ethan Dingman is the contributor to the DNA. They're on his pants. But then also in the second portion, the analysis provides very strong support.
It's very difficult to determine. I read these during lunch. To your credit, you sent them up this morning. Otherwise, they were just admitted like 2 minutes ago. It's difficult to match each item to each report without a careful cross referencing.
And that's the purpose of the stipulation between the parties at the beginning, that the items described in People's Exhibits 13 and 14 are those same items that were recovered from Mr. Dingman during the course of the investigation.
Oh, well, for example, and we're looking at page 2 of exhibit number 5, the very first item. Hypothesis, GR 19712-10DA. Hypothesis, Ethan Dingman and one unrelated unknown contributor. Hypothesis 2, 2 unknown unrelated contributors. Ethan Dingman is excluded as a possible contributor to the DNA contained in the shoe swab. Then the next one, and again, you have to very carefully cross-reference it, 7142-13E, Todd Schwarz is a contributor to the DNA profile on the shoe swab. Interpretation from the pant swab was performed, assuming the DNA profile originated from 3 individuals. Because I didn't want to get in a situation in the middle of this examination that we couldn't turn off the live chat. All right, we're back up. We're running. And the live stream is back on, the chat is off. I apologize, I interrupted you, but I was having trouble cross-referencing each of the references in the DNA. And your representation that his clothing was covered with DNA, I certainly didn't see that in the pictures. Maybe the shoes, but all right, I'll let you finish and then we'll hear from Mr. Weis.
And again, I think that when we are looking at the lab report, the shoe, you can see it. The pants, when you look at people's exhibits of the pants, there's some sort of staining that's present on the pant that's visible to the naked eye. I indicated that I do not believe there's anything to the naked eye that's present on the shirt. However, it was revealed in the MSP lab report number 3 through their testing that there was potential DNA on there as well. And then again, the glasses, you can see a couple of spots of blood on the photos that the people have submitted. And then again, in lab report 3, it indicated that there was the possible presence of blood, and the testing did come back with that being the DNA for Mr. Schwarz. So when I'm saying that the DNA is all over, I don't want to misrepresent by saying he's covered head to toe in someone else's blood in terms of there's no skin visible or anything like that, but that on each of these pieces of clothing that he's wearing and also the items that were discovered on his person, that they do go back to having both, some of them, both his DNA as well as Mr. Schwartz's DNA, and some of them, such as choose only Mr. Schwartz's DNA, which goes to contradict then the statement that he didn't touch him, he didn't render aid, anything along those lines. He in fact was there, present, covered in his blood when he's bleeding from this laceration to the back of his head, which gives probable cause that he's the individual who did this.
Well, his fingernails are described as 19714212D and a fingernail swab 12E. Was any blood found on Mr. Dingman's hands or in his fingernail swabs?
The fingernail swabs, I believe, if you go back and you look at exhibit 13, it's not clear in here. My understanding, those fingernail swabs, though, if you look at the pathology report, so People's Exhibit 1 from Dr. DeYoung, she took fingernails clippings of the victim, Mr. Schwarz, and those were submitted for testing for the purposes of DNA. Those are the fingernail clippings that were then tested here. That was not one of the things that we stipulated to or talked to in this report, but my understanding is there was no fingernail clippings with Mr. Dingman. That's not in evidence, but what is in evidence is that fingernail clippings were taken from Mr. Schwarz. Those are the fingernails that then were processed in People's Exhibit 13 and 14, and that do not come back and show any DNA. So it's not Mr. Dingman's fingernail clippings, it's Mr. Schwartz's fingernail clippings. And in People's Exhibit 1, it's page 8 of 8, about the very last item, it's the 4th bullet point.
There was testimony from Deputy Hughes that he took swabs of the defendant's hands and with distilled swabs. There's no evidence here in this record regarding any evidence from the person of Mr. Dingman.
That's correct.
All right, I'll let you finish.
I believe that I already concluded requesting bind over, Your Honor.
All right. Mr. Weis?
Thank you very much, Your Honor. First and foremost, I would move Your Honor to strike or to not to consider any statement provided by Mr. Dingman, and that includes anything from his initial interview with Chief Freaker right on through what I believe would have been the fourth statement to the two detectives at the county complex. The testimony from Trooper Bourgeois was that Mr. Dingman approached her and she directed him to stay at Chief Freaker's car. Chief Freaker then says, yes, he's at my car. I put him in my car. Amazingly, Chief Freaker testified, he's in my car for mere moments after I had been in the crime scene for 3 minutes. Doesn't make really incriminating statements. And the chief steps out of the car, goes back to the officers and says, I've got my suspect. I'm not 110% sure, but I have my suspect. That leads to Mr. Dingman being detained even longer and now in the backseat of the officer's car where he can't leave. He's not free to leave. And at no point in time at any of law enforcement's interactions with Mr. Dingman do they Mirandize him. Do they tell him he's free to leave? Do they ask him if he wants to leave? Do they ask him if he consents to questioning? There's just nothing. Nothing at all. It's just, well, he didn't say anything. And so we assume he's just consented to these voluntary conversations. And the chief even said, well, yeah, he's in custody. When I pressed him at, and I believe it was the second interaction with Mr. Dingman. Certainly by the time we get to the jail, the administrative side of the county complex, for the fourth interview, after being moved from the scene, the idea that Brinkert is going to make the decision that this is all voluntary is troubling on its face. And I would ask Your Honor to find a Miranda violation at every step of the way and not consider anything that Mr. Dingman set forth. Even if Your Honor doesn't go there, as the court's already stated, many of the statements were exculpatory. And it seems what the prosecutor is trying to do is cut and paste some inconsistencies and try to equate that to probable cause. When the record is clear that the officers who interviewed Mr. Dingman were concerned about his mental health, the record is clear. Every step of the way, he is just throwing things out there out of left field that make absolutely no sense. Reasonable inference, I mean, can you really trust, believe anything this person is saying? Even if it is somehow woven into some sort of an incriminating posture. And even if it is that, don't we have sort of a corpus delicti problem here of considering these statements? Even if there's no Miranda warning, and even if there's inconsistent, I mean, where are we going to go with that? And even then,
Well,
and I know you're not a jury, but there are just countless.
Describe further your corpus delicti problem. We certainly have evidence that a crime was committed. Even from first initial viewing of it, the person's laying there and there's blood all over. Hey, what was your reference regarding lack of corpus delicti?
Well, we have probable, I would concede that there's probable cause. The doctor did testify that it was her opinion that there's probable cause that the death was caused at the hand of another. I suppose it could have been self-defense. I suppose it could have been any number of things, but for the purposes of exam, I would retract that argument.
All right, thank you.
But what we also know, Your Honor, and it's unfortunate that we didn't have the 911 call on the record here today. The only inference we have, or the only testimony we have, is that Ethan evidently made the 911 call. The trooper said, "Hey, I've got the caller here," and the chief's characterization of his being dispatched out there, I believe he described it as a medical. I was dispatched to a medical. So reasonable inferences there could certainly explain any type of physical evidence that may exist. We have somebody who found a body and called 911. That's what we have here. That's what we have here. And they're trying to weave this, well, he said he didn't want to touch it, and they're trying to weave this banana, and that equates to a murder. And that's thinner than thin, Your Honor. When the government spends more of their time talking about the forensic pathologist, that leaves me, okay, we have a death, which is tragic and unfortunate, but the record here is painfully lacking with respect to probable cause as to who may have done it. It's certainly lacking as to whether any indication that Mr. Dingman played a hand in the actual death of Mr. Schwarz. So I would oppose the bind over for lack of probable cause, and I would really tempt Your Honor to go through an analysis on those statements with respect to custodial interrogation.
Any rebuttal?
Yes, briefly, Your Honor. First, in regards to Mr. Dingman's statement, they were not a violation of Miranda. The police certainly have the ability to conduct an investigatory interrogation of an individual short of a custodial interrogation. I mean, that's common constitutional law that we all understand. We're used to it, maybe more in the drunk driving context or in other contexts, but certainly if they have reasonable suspicion that criminal activity is afoot, they have the opportunity to detain Mr. Dingman for the purpose of confirming or dispelling that suspicion without triggering the need for Miranda to be invoked. That's what happened here. That's what was discussed throughout the course, both in terms of with Chief Brinkert, but then also with Mr. Dingman, Mr. Dingman's participation at the sheriff's office. But even if we don't take into consideration Mr. Dingman's statement, what we know is that Mr. Schwarz did not walk up and leave that garage that day. Yet from that pool of blood, there is footprints found in the ground. We see on Mr. Dingman's shoes the blood of Mr. Todd Schwarz, but the blood is not limited to his shoes. He didn't just wander in there. It's on his pants, it's on his shirt, it's on a pair of glasses that belong to Mr. Schwarz that we have in People's Exhibit 2. We see him wearing them. The DNA is found on there as well. And it's not like it's just some random touch DNA. You can see on the glasses that there's blood on those glasses as well. It's also on Mr. Dingman's shirt. He has Mr. Schwarz's blood. The blood that was the result of an intentionally inflicted injury on his person. For the purposes of a preliminary examination and a probable cause determination, that evidence is sufficient, and we request that you would find the matter over to circuit court.
All right. I had hoped also to hear some evidence of footprint matching from the footprints in the garage to the shoes of the defendant. And I don't know whether that exists, or if it does, what the status of it is. I'm very concerned about the admissibility of the statements once Mr. Dingman is put in the back of the patrol car. Voluntariness is in the eyes of the holder. Suppose to call it voluntary doesn't make it voluntary. The defendant is obviously struggling with mental health problems, and it was apparent to everybody who was dealing with him at that point. There was no evidence that he was covered in blood or had blood on his hands or face or obvious blood in his possession. He was put in the car, apparently didn't leave blood all over the car. There's apparently, if there is any evidence of blood on his hands, it's not in this record. And Mr. Weis alleges that he's a guy who was mentally ill, found a body and called 911. The next thing he knew, he was in custody, not well able to articulate his point of view. Clearly, once he asked for his attorney, any questioning after that point is almost black letter. Unfortunately, the entire interview conducted with the defendant at the sheriff's department is not recorded, which makes it almost worthless. Mr. Weis is correct. I need to take a closer look at the timelines of each interrogation and determine, certainly that I think the first questioning by Chief Brinkert, obviously the guy found the body or he wouldn't have called it in. He didn't run away. He didn't hide. He walked next door to the Shell station and called 911. Apparently, within a brief time of when he saw the body. So there's a lot of unknowns here. The prosecutor's case rests on the fact that the defendant said, I didn't do anything. I didn't want to touch the body. I didn't want to get blood all over. So I want to look at the forensic report more carefully, and I want to dissect the different interviews. It appears to me that in the report there are some other DNA contributors that are not accounted for. And that's troubling to me. So I need to make sure I understand that. So is everybody available tomorrow morning at 10 o'clock?
Your Honor, I am not. I have a hearing in Grand Rapids. I can be available 11:30.
How's your afternoon?
I'll make myself available.
All right, can we reconvene at 1 o'clock?
Yes, Your Honor.
Yes.
All right, I'm going to carefully review the testimony. As conceded, the first prong of this was this a homicide is not difficult. There's certainly probable cause that there was a killing under unjustified circumstances. The question is there enough admissible evidence to raise it to a level of probable cause that this defendant did it? And that's a very low standard, Mr. Dingman. It's certainly a lot lower than proof beyond a reasonable doubt. Probable cause is even less than a preponderance of evidence. In the scheme of evidence, at 0 is no evidence, and at 100% is absolute evidence. Well, we never get that. There are different standards. One is reasonable suspicion. That's down here in, I don't know, the 15% range. Then there's a preponderance, which means more than half, 51%. That's the standard in a civil case. To prevail in a civil case, you have to prevail beyond a preponderance of evidence, so it's just 51%. To convict somebody at a jury trial, beyond a reasonable doubt, is a difficult standard to meet. It's up closer to the 100% end. Well, the probable cause standard for a preliminary examination is somewhere between reasonable suspicion and preponderance of evidence. It's less than 50% and maybe more than 15%. It's a probable cause to believe that something would have occurred. And there's no hard and fast formula on what is probable cause. You have to view it in light of all the circumstances. So the standard is not very high to find probable cause, but I have a concern that even that standard has not been met here. So we will resume tomorrow at 1 o'clock. I will carefully review the testimony, and I want to cross-reference the DNA reports. And I didn't have very much time to read them. I finished at noon. I worked through lunch, and then we started right at 1 o'clock. So I'm gonna have to chart these out, but I'll have enough time to do that. All right, we'll resume tomorrow at 1 o'clock. Anybody is welcome to either come back in, Mrs. Dingman or Officer Males, or simply go on the YouTube feed. Same with you. You're all welcome to come back tomorrow at 1 or log in at the number the prosecutor will give you, or just watch it on the feed. But I want to do some careful analysis of this. It's a very important decision. All right, anything else we should place on the record?
Thank you, Your Honor.
Your Honor, thank you very much for your time and consideration, and it is serious, and we appreciate it. Ms. Shepard and I do have one more stipulation, and that's Judge Pattison clearly owes you at least one lunch, if not two, for having to get involved in this file, and we're not talking about hot now either, Your Honor.
All right, well, it is what it is, and I'll try to do the best I can. And I will see you all tomorrow at 1 o'clock.
Thank you very much.
All right, thank you. Mr. Dingman, we'll have you brought up again tomorrow at 1. All right, we're going to end the. All right, we're ready to continue our record, the matter of People versus Ethan Nicholas Dingman. Mr. Dingman, can you hear me? All right, why don't you go ahead and take your mask off so you can be more comfortable and we can see you. The parties that were here yesterday essentially are here again today. Ms. Amy Shepard from the Kalamazoo County Prosecutor's Office, Special Prosecutor, is here. Mr. William Weis, attorney for the defendant, is here. Chief Mark Brinkert, the officer in charge of the case, is present. Family members of Mr. Schwarz are present, and the defendant's mother is present on the live feed. Anyway, this is the time, as the court announced, that it would rule on the prosecutor's motion to bind the matter over to circuit court. Before I do that, Ms. Shepard, I'd like to have an opportunity to view the exhibits again. I've got the forensic reports, I've reviewed them, but I just had a fleeting glance at each of the exhibits, and I didn't have a copy or a thumb drive or a picture. So could I see them once again? Could you screen share them? I think through.
Of the photographs?
Yes.
Oops, share. I am having less success than I did yesterday.
Well, I didn't give you any warnings, so. But normally after the prelim, I would have the pictures.
Yes.
So this is, I think, number 3.
Yes.
Yes, 3. All right. Okay. All right, that's the banana. Those are the top of the shoes. All right, next. Bottom of the shoes. Next. bottom of the right shoe, which is number 7. Okay. Pair of eyeglasses, which is exhibit number 8. Closer view of the eyeglasses. Exhibit 9. A picture of what looks to be a pair of sweatpants. Exhibit 10. Okay. Exhibit 11, which appears to be a gray flannel lined shirt, or green and green, I guess. That's exhibit number 11.
And then I should have started with exhibit 2. It's just saved as a PDF, and so that's why it didn't open. So I think
Well,
I have,
you also showed me a picture of Mr. Schwarz wearing a pair of glasses.
yes, so that's the one I'm opening right now. That's people's exhibit 2.
Could you show me his head again?
Mr. Schwartz's head?
Mr. Schwarz, yes. Okay. Now can I see 5 and 6, the picture of the glasses?
Yes. Of the glasses or of 5 and 6?
The glasses. I may have my numbers wrong. Maybe it's 6 and 7. Okay. Back to 2, if you could.
Yep.
All right, thank you. We heard testimony yesterday from several witnesses. Chief Brinkert, Trooper Burgoyes, the pathologist, Ms. DeYoung, Deputy Hughes, and Deputy Herman. And I think that was it. And then we heard argument. And the court had a number of questions and concerns, and still does. The plaintiff, in this case the prosecution, has the right to present as much evidence as they wish at a preliminary examination. It is a hearing only where there's a determination of probable cause. I mentioned that to you yesterday, Mr. Dingman. And I kept hoping there was more. When we got there, there was no there. Ms. Shepard, at this late hour, I would grant you a week if there's any additional evidence you wish to produce at this preliminary examination. Is there anything else you'd wish the court to consider before I make my ruling?
I know that Your Honor indicated there were some questions in regards to the meaning of some of the statements in the DNA lab reports. And so the people would be prepared to produce the experts in those areas to further explain what that is. And so we would take that week in order to do that. And then also, if there's any other evidence that we could add to what we have presented already, we could do that.
Well, I'm not going to tell you what to present. The reports seem to indicate to me there were other sources of DNA. The defense didn't argue this, so I wasn't sure I was understanding it correctly. But the report says, Exhibit 14, on page 5. The second one. Ethan Dingman, let's look at this. You have to index the numbers. Ethan Dingman is excluded as the first one, as a possible contributor to the DNA on the shoe swab. Okay, that doesn't tell us much. Second one, 13E, shoe swab. Based on the DNA typing results obtained from the shoe swab, it is likely that it originated from Todd Schwarz and one unrelated or unknown contributor. So one of the samples appears to be Todd Schwarz blood or DNA, and the other one we don't know who it is. The pants at the bottom, 10A, hypothesis, Ethan Dingman and 2 unknown contributors, or 3 unknown contributors. Interpretation, based on the DNA typing results obtained from the pants swab, it is more likely that it originated from Ethan Dingman and 2 unrelated unknown contributors. So there are 2 other sources of DNA on his pants, his and 2 unknowns. So then we go further. Todd Schwarz and 2 unrelated unknown contributors. Based on the DNA typing results, it is 92 septillion times more likely it originated from Todd Schwarz and 2 unrelated unknown contributors. So there's another source of DNA on the pants. One solid piece of evidence seems to be the lenses. Based on the DNA typing results, it is 150 octillion times more likely it originated from Todd Schwarz. So the blood on the glasses was from Todd Schwarz. Then the earpieces, they didn't find anything. Then the shirt, and I'm a little concerned. The lab report, Exhibit 13, indicates 71428 is a shirt. 71429 is a sweatshirt. Deputy Hughes didn't testify that he seized a sweatshirt. So I'm assuming the shirt we're talking about is the green plaid shirt from the picture. But the lab report indicates a sweatshirt. I have no idea where it's from. the testimony of Officer Hughes didn't include a sweatshirt. All right, so we go back to this. Ethan Dingman and 2 unrelated unknown contributors. Based on the DNA typing results from the shirt swab, it is more likely it originated from Ethan Dingman and 2 unrelated unknown contributors. So Ethan Dingman's DNA is on Ethan Dingman's shirt. Then we go to the next one. Todd Schwarz and 2 unrelated unknown contributors. Based on DNA typing results obtained from the shirt swab, it is likely it originated from Todd Schwarz and 2 unrelated unknown contributors. One of them is Ethan Dingman. We don't know who the third source of DNA on the shirt is. And then none of these were entered into CODIS. DNA profiles were not entered into the Combined DNA Index CODIS, and that stands for Combined DNA Index System, kept by the FBI and the state police and most other states. So my reading of those laboratory reports is we have some unknown sources of DNA on the shoes, on the pants, and on the shirt. I don't know if I'm interpreting that incorrectly, but that's what it looks like to me. So are you asking to take me up on the offer to present the laboratory witness?
Yes, I will take you up on that offer, Your Honor.
All right. Any other evidence you wish to produce?
At this point, not that I can think of. If that changes, I would reach out to Mr. to see if there would be a stipulation in regards to that prior to us returning to court.
All right. I am concerned because Mr. Dingman's been in custody for 588 days. And it does not appear to me that you have enough evidence to bind this matter over to circuit court. And I'm going to leave him in custody pending further evidence. And so I don't want to do it very long. I spent several hours last night and 5 hours or 6 hours this morning going over this in minute detail. And my fear is, as I said, there's no there. One week to next Tuesday, June 8th at 1 o'clock. May have to clear the decks and have Judge Pattison handle some of the other things. Had that stood out to anyone else? Am I reading into this more than is there?
I'm sorry, Your Honor, can you repeat the question?
Well, I guess I'll just leave it. I'll wait for the witness to come and tell me if I'm on the right track or not. But the way I read the reports, there's some unidentified DNA evidence on several of the exhibits.
And I believe, we would be able to reopen argument at that time, but again, we're looking at Mr. Dingman's clothing. It's not Mr. Schwartz's clothing that this is the question about, which I think would be something for us to revisit when we, after we hear from these witnesses from the crime lab.
All right. I'm aware of that. But if the allegation is this is transferred evidence from the scene, you're right, it could be anybody's DNA on the defendant's clothing. So if your argument is it isn't relevant, but I guess we'd at least like to know the answer to it. I'm not sure it's gonna swing it, but I'll just leave it at that. I've given you the opportunity to present any additional evidence. If you've got some smoking gun that's in the background, I'm certainly willing to hear about it. But all right, we'll continue this to June 8th at 1 p.m.
Your Honor,
Yes?
begging the court's indulgence, where are you, if anywhere, pertaining to your analysis of custodial interrogation?
My sense of it is, once he was placed in the back seat of Officer Brinkert's car, he was in custody. He was put in Officer Brinkert's car. He was put in the back of Deputy Dingman's car. He was locked in both times. He was put in the back seat of the car and driven to the jail in Centerville. He certainly was arguably in custody at the time he was at Centerville. But frankly, nothing that incriminating. Was introduced. It was said sort of as an aside by Officer Males, Detective Males, I left him out, that the defendant changed his story 4 times. And apparently the prosecutor was there watching it. The defendant was a paranoid schizophrenic and struggling, and nowhere was he ever advised of his Miranda rights. And so taking the totality of the circumstance, I was ready to speak to this further, but the early statements to Officer Brinkert are admissible. And then the line becomes grayer and grayer until it's a black line, after which point he was clearly in custody. They interviewed him for 3 hours from 9:30 to 1:30, and then they advised him of his Miranda rights. While the prosecutor was there watching. Anyway, most of what in fact, I would submit everything he said to Officer Males is inadmissible. Much of what the early stuff that he said to Officer Brinkert is admissible. But there's not that much, there's no terribly damning evidence any more than what he said to Officer Brinkert. I'll save that for later, but that's where I'm leaning at this point, unless I can be convinced otherwise. As I said, I spent 3 hours last night and 6 hours this morning preparing for this, so it's like I let all the air out of my balloon, but I thought I would give you an opportunity to present any additional evidence. Mr. Dingman, can you hear me? All right, we're going to continue this for 1 week until next Tuesday at 1 o'clock. It will be by Zoom like this once again, and everybody that's here will be welcome to return. We'll take some testimony, perhaps further argument, and perhaps my interpretation is exactly correct, that there is an unknown potential donor, but that it doesn't matter because it's on your clothes. And on the clothing, it doesn't bother me so much. On the shoes, perhaps it does. So, all right, that's what we got. We'll just have to think about this over the weekend and reconvene next Tuesday at 1 o'clock.
Will we receive new notices or should we just rely on the notices from yesterday?
We'll do new notices.
Thank you.
See you guys next Tuesday. Thank you all very much.
All right, thank you.
Thank you for your time.
Thank you. All right, we will be back. I'm sorry, that's all we got accomplished, but we'll stop live streaming. And Mr. Dingman, you're free to go. Mrs. Dingman, I will see you the same way next Tuesday.
Yeah, thank you.
All right, I'm sorry. I think we've got what we need. At any rate, this is the time and date for the continued preliminary examination in this case. Court gave the opportunity for the prosecution to present any additional evidence if they wished. The matter was continued till this time and date. Ms. Shepard, do you wish to produce any additional evidence?
Yes, Your Honor. The people intend to call two witnesses. That would be Paul Donald and Michelle Schmidt, both from the Michigan State Police Forensic Laboratory in Grand Rapids. Additionally, we have one more report that we would submit to the court pursuant to MCL 766.11B1D. I did email mid-morning Mr. Weis about this to see if he had any objections or if we could stipulate so I could send it to the court ahead of time. However, I believe he was otherwise occupied and did not get to see that email until right before we came into court. And so I would be moving to admit that at the end of the testimony of these other two witnesses. But I'm just making the court aware of that at this time.
All right, thank you. All right, who do you wish to call first?
We will call Paul Donald.
Do you want me to clue Michelle Schmidt in as to what we're doing?
I told her yes to Friday how we would be proceeding, so she was aware that Mr. Donald would be testifying before her.
All right. Good afternoon, sir. Are
Hello.
you Paul?
Yes, sir.
Would you raise your right hand, please? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Would you state your name and spell your first and last name, please?
Paul Donald. Paul-Donald.
Thank you, Mr. Donald. Prosecutor Amy Shepard has questions for you, and then Defense Counsel Mr. William Weis will have some questions for you as well. Madam Prosecutor?
Thank you, Your Honor. Mr. Donald, where do you work?
I work at the Michigan State Police Crime Lab, which is located in Grand Rapids.
And what do you do there?
I perform forensic biology.
Now, in your capacity as performing forensic biology for the crime lab, are part of your responsibilities examining evidence for the potential for DNA analysis? All right, and I'm sorry, I couldn't hear that. Could you state your answer again?
Yes.
Thank you. And is there a standard procedure that you follow in performing this type of inspection?
Absolutely.
And what's that standard procedure?
Well, when given items like articles of clothing, the procedure starts with a visual examination of the items in order to determine if there are any plainly visible stains on the items. And then after a cursory visual examination of the evidence, then the items can be subjected to an alternate light source if necessary in order to enhance any stains that may or may not be visible under just normal visible light conditions. And then once any particularly interesting stains are identified, then move on to a presumptive screening tests that can be used to determine whether or not the stains can be, like, for instance, a reddish brown stain could be a blood stain, or if a stain that's not visible with the naked eye that lights up with the alternate light source, that could be tested for possibly semen or saliva. And then once any particular stains of interest are identified, then a sample of those areas of interest are collected and stored in a sterile environment until they can be processed with DNA analysis.
In terms of the presumptive screenings, are you familiar with something called hemosticks?
Yes.
And is that something that you use for in performing these presumptive screenings?
Yes.
And can you describe for the court what hemosticks is and how you use it?
First, could you spell it for the reporter?
Absolutely. Hemosticks is
We're
spelled-
losing your microphone. You're in and out a little bit.
Hemosticks is spelled HEMASTIX. And it's a trademarked item that's available predominantly for use in testing for blood, like for people who might have diabetes can use these test strips to check their urine for blood. So they're very sensitive for blood, and they're very sensitive for some. They will react with other things too. So it's not very specific, but it's very sensitive. So we use them to test for the possibility of blood. And so it's a color test, and an unused hemosticks is yellow, and when it comes in contact with blood, it turns a dark green. So it's very clear if possibly blood has touched the hemostic. So we would call that a positive result.
Now, you indicated that after performing a visual observation, as well as potentially if you have to do any other observations, like with an alternative light source, and performing these presumptive screenings, that you collect samples. How do you go about collecting those samples?
On the item of evidence, either a sterile swab can be used to collect a stain, or an actual cut of the item that the blood stain is on can be taken from the item in order to be forwarded to DNA for analysis.
Is there a reason why you might choose to swab something or to cut something rather than the other?
So, like for instance, a hard non-porous surface would definitely be easier to take a swab of that item. And then for items like clothing, clothing offers more of a possibility for a mixture of future DNA analysis, because you might get DNA that was imparted on the item prior to the event in question, or like DNA from the person that was wearing the clothing. So depending on the nature of the sample that's being collected, sometimes it might be better to actually take a swab of an area of clothing that might have a blood stain on it, as opposed to a cut of that item, in order to kind of reduce the possibility of a DNA mixture future down the road.
Now, in the course of your employment with the Michigan State Police Forensic Laboratory, did you assist with the investigation in a case involving a suspect of Ethan Dingman and the victim of Todd Schwarz?
Yes,
And in fact, did you respond to the scene initially in this case in order to assist?
don't recall.
Okay, but following that, did you have the opportunity to inspect some items that had been collected into evidence to determine whether or not they may be suitable for DNA analysis? And following this investigation or this process, did you author a report summarizing your findings? And I'm sorry, you're breaking out again. Was that a yes?
Yes.
I'm going to show you on the screen share what's already been admitted into evidence as People's Exhibit 13. Oop. Do you see the item on your screen?
Yes.
Do you recognize this document? If you need to see more, that's okay.
Yes, it looks familiar, and I see my signature at the bottom of the report at the signature block area.
So is this the report that you authored summarizing your examination of the various pieces of evidence?
Yes.
So I'd just like to go through a few of these pieces of evidence with you. Starting with what's been labeled in your report as GR19-7142-1. Those items on your report are indicated as shoes. Did you examine those shoes for the possibility of DNA or for suitability for DNA analysis?
Yes.
And how did you go about doing that?
Well, like I said before, starting with the visual examination, and there were reddish brown stains readily visible on these shoes, and there were reddish brown stains noted on the tops of both shoes, on the side of the shoes, and on the bottom of the right shoe.
After observing this, did you also perform a presumptive screening?
Yes.
And how did you do that?
I selected 2 areas of the right shoe, and one from the top and one from the bottom, and they were both positive for the possible presence of blood.
Now, did you go about performing or collecting a sample for possible DNA analysis?
Yes.
And how did you do that for the shoes?
That involves just taking a sterile swab, and you moisten it with a little bit of sterile water, and then you just rub gently on the reddish brown stain that's been identified as possibly blood. And then it's dried, and then the portion of the swab that lifted the blood stain is cut away from the swab and placed in a sterile microcentrifuge tube, and then it's placed in frozen storage until it can be processed in the future for DNA analysis.
And why did you decide to go with a swab in this instance as opposed to a cutting of the shoe?
Well, shoes are a thick, porous surface that can be difficult to cut. So, like my example earlier with hard surfaces, it's more convenient to take a swab of the stained area. And in addition, if you're taking a cut of that shoe, you may be getting layers of years worth of other stuff that's been imparted on the shoe prior to the event in question, whereas a sterile swab lightly rubbed on the top of that affected area will likely just focus on picking up the most recent event that imparted the reddish brown stain on the shoe, as opposed to the history of the shoe.
And when you're worried about other stuff, do you mean also potentially other DNA contributors?
Absolutely.
Moving on to DR 19-7142-3. And your report indicates that those are pants. However, there's two different pants listed on the report, specifically regarding GR 19-7142-3. Which pants are those?
They're a pair of, I'm guessing nylon sport pants.
And when you say you're guessing, do you mean as to like the material that makes up the pants?
Correct.
And did you find that it might be provide the potential for analysis for the presence of DNA?
Yes.
And how did you determine that?
Well, there were some reddish brown stains that were visible under normal lighting, and then with the aid of an alternate light source, there were several smaller stains that were also noted on the pants.
And so then did you perform a presumptive test on them as well?
Yes.
And was that positive?
Yes.
And did you end up taking a sample for the purposes of potential DNA analysis?
Yes.
And was it a swab this time as well?
Yes.
Moving on to GR 19-7142-7, items listed in your report as glasses. How did you evaluate those?
First of all, after taking the glasses out of the sealed package that it was submitted to the laboratory, and there was just a cursory visual examination of the item, and on the glasses there were 4 reddish brown stains that were readily noted on the glasses.
And did you also do a presumptive test on those stains as well?
Yes.
And was it positive?
Yes.
And did you take a sample for testing purposes?
Actually, 2 samples were taken from the glasses.
Okay. And were those samples swabs again?
Yes.
Moving on to GR 19-7142-8, listed as a shirt. Do you remember how the shirt appeared, what color it was?
Yes, it was a light gray shirt and had some writing on the front of it.
Just a minute. I'm not seeing a 19. Evidence received 1 through 12.
And I think I misspoke. Let me try again.
Because there's 2 shirts.
Yes. And so in regards to GR, I'm doing this right. GR 19-71428. Is that the item listed as a shirt in your report?
Yes.
And then GR 17-71429 is listed as a sweatshirt?
Yes.
All right. In regards to the shirt, what color is the shirt?
I believe it was a gray t-shirt. Had some writing on the front of it.
All right. And in regards to the sweatshirt?
Color of the sweatshirt?
Yes.
That was hard to tell. The sweatshirt was essentially soaked in blood and it was putrid. I didn't make a note of color of the sweatshirt.
Okay. All right. And in regards to that t-shirt, the GR 19-7142-8, did you, what did you do to see whether or not it would be suitable for DNA analysis?
With the presumptive test with the hemosticks as before.
And was that positive?
Yes.
And did you take samples for testing?
Yes.
And how did you do those?
With a sterile swab and just moistened with sterile water, like before, like I said before, and then lightly rubbed on the blood stain that was on the shirt.
Now, moving on to item GR 19-7142-10D, was that a listed or a submitted buccal swab from the suspect in this case?
You asking about item 10D?
Yes.
Okay.
I don't have a 10D, I have a 10.
I think if you scroll, or if you go down to the second page of the report, the very last item on page 2.
Okay.
And I think to clarify that, Mr. Donald, in Michigan State Laboratory reports, if a lab number is followed by the letter of lowercase d, what does that mean?
That's a sample of an item. So the D just signifies or denotes a derivative sample that was taken from a larger evidence item. So in this case, the item would have been identified as 10, and then the sample that's taken from item 10, we add a little D in order to signify that that sample was taken and forwarded to DNA for DNA analysis.
And is that what happened in this case with the buccal swab from Ethan Dingman?
Yes.
And finally, moving on to item GR 19-7142-12, listed as fingernails. Did you attempt to do anything to see if they were suitable for DNA analysis?
Yes. So with regard to the fingernails, I guess the goal with regard to something like a victim's fingernails is to try to determine if their hands came into contact with anything, and during the event in question. And so, like in situations like this where there may or may not be reddish brown stains on fingernails, when I'm collecting a sample from the fingernails, if there's reddish brown stains, it's safe to assume that those large reddish brown stains could be attributed to the victim. So I would focus to areas that don't have reddish brown stains in case there's the opportunity to possibly collect microscopic amounts of contact or transfer DNA that might be stuck underneath the fingernails.
And is that something that you did in this case?
Yes.
And how is it that you take a sample from the areas that wouldn't have any staining on it?
Well, just like I explained before, with taking a sterile swab that's moistened with sterile water, and then and again focusing on those areas away from the reddish brown stains to try to get a sample of any potential DNA that might have been imparted onto the fingernails.
And when you testified in regards to the sample taken from the shoes, you also testified to the process of preserving the items for ultimately being analyzed for potential DNA analysis. Was that the same thing you did with the rest of the samples, the items we've just discussed?
Absolutely.
Thank you, Mr. Donald. I don't have any further questions from you at this moment, but Mr. Weis may.
Mr. Weis?
No questions, Your Honor. Thank you.
I have a couple. Could we show the items to the witness the photographs?
Yes. This has been admitted into into evidence as People's Exhibit 3. It would help if I shared my screen.
All right, stop. There's a pair of shoes, and I can't tell if that's the color they are or there's something on them. Are you saying those shoes I'm looking at are blood soaked on the top?
Well, I certainly wouldn't say they were soaked in blood, but there definitely were reddish brown stains on those shoes and on the bottom of the right shoe.
All right, but is the color, that color of the shoe is not blood color, it's just there, you're saying there's some stains of blood on the shoes?
Yes.
The laces of the right shoe look dirtier than the laces of the left shoe. Is that blood on there?
My notes don't indicate that reddish brown stains were noticed on the dirty laces. It was just on the top of the shoe, the actual shoe, on the side of the shoes, and on the bottom of the right shoe.
All right, go ahead. All right, there's a little red mark on the bottom of the right shoe. Is that what you're talking about?
Yes. Near the circle area.
Near the circle area, I don't see that. I see a horizontal red thing in the middle of the shoe on the instep. Is that what you're talking about?
My notes indicate in the pattern of the circle on the bottom of the right shoe was where a reddish brown stain was noted.
We can't see that very well, but the shoes don't appear to be blood soaked on the bottom or anything, do they?
No.
All right, thank you. Next. So that red thing we're seeing in the middle of the shoe is not relevant?
Not in the arch area. That's just soil.
Okay. Thank you, that's helpful. All right, next. And those are consistent with the glasses you examined?
Yes, sir.
Next, which would be Exhibit 9, a close-up of the glasses. All right, next. And those are consistent with the nylon pants you examined?
Yes, sir.
Where were the stains there?
As I recall, the larger stains were near the kind of like just above the knee area, and then the smaller stains were found near the cuff of both of the pant legs.
So there's a big stain right in the middle of the front near the waistband. Those are not blood?
No, sir.
So there's a couple of stains we can't see in this picture, but you could see them either there or with alternate light.
Correct.
All right, the next one. You testified to a blood-soaked sweatshirt, and so at this point, I've heard no testimony about any blood-soaked sweatshirt, blood-soaked or otherwise. This is exhibit number 11. It appears to be a plaid lined flannel type shirt. Did you examine this?
I'm not sure. I have my item 11 as a reference sample.
All right. Next. These aren't really relevant. You mentioned a T-shirt with writing on it. There was some discrepancy between what the deputy testified to and what was in the lab report, but I don't have any evidence of a blood-soaked sweatshirt. Which would be item 9 on your exhibit on the report. All right, Mr. Weis, does that raise any questions for you?
No, Your Honor, thank you.
All right, anything further, Madam Prosecutor?
Very briefly, Mr. Donald, in regards to item number 9, your report does not indicate that you took any swabs from that for the purposes of DNA testing. Why is that the case?
Well, since the item was soaked in blood, and I recall it may have been the victim's sweatshirt, and so that taking a sample from that would just be the victim's blood. So, and since it was completely covered in blood, that there didn't really seem to be a need to take a sample of that sweatshirt.
And then my last question is, Judge Middleton was asking questions about whether the shoes were blood soaked or other item. How much of a potential source of DNA is there needed for you to take a swab in order for a potential analysis to be conducted?
Well, I would, just roughly speaking, the amount of sample, the DNA testing is so sensitive that it could almost be a sample that you almost couldn't even see, and still quite possibly get a DNA result out of it. So, yeah, when taking a sample from blood stains like from on the shoes and the pants, for instance, the stains were large enough to actually turn that white sterile swab reddish brown from collecting those stains. But yeah, certainly, when attempting to collect a stain, if you've identified a stained area and tried to take a swab of that area, even though you may or may not see a light reddish brown stain on that swab, it's very, very possible to actually get a DNA profile from something that you actually can't see with the naked eye.
Thank you very much. I have no further questions, Your Honor.
All right, Mr. Paul, thank you for your time. The advent of the Polycom and now Zoom certainly has saved you lab guys lots of road miles and made it easier for all concerned, at least for prelims. All right, sir, thank you for being with us. Next, you want Michelle Schmidt?
Yes, please.
Hold on, I can't see anything.
Good afternoon, Ms. Schmidt.
Good afternoon.
My name is Judge Middleton. I'm here at the court in Centerville. Thank you for being with us. Prosecutor Amy Shepard has subpoenaed you to be in this matter. I'm going to ask if you would please raise your right hand.
Yes, let me just turn up the volume just a touch, please, sir. I'm sorry.
Be helpful. We had a little struggle on the last witness. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Would you state your name for the record, please, and spell both your first and last name?
My name is Michelle, Michelle Schmidt, Schmitt.
All right, Ms. Shepard.
Thank you, Your Honor. And if I may just ask very briefly of Mr. Weis, I'd sent an email asking if we could stipulate. All right. So the parties have stipulated to Ms. Schmidt being able to testify as an expert in the field of DNA analysis and statistical calculations regarding DNA samples.
All right, you so stipulate, Mr. Weis?
Yes, Your Honor, thank you.
I could see you nod your head, but it didn't show on the record. All right, you are qualified as an expert in the field of DNA analysis and statistical analysis. All right.
Ms. Schmidt, where do you work?
I'm currently employed at the Michigan State Police in the Grand Rapids Laboratory in the Biology and DNA Unit.
And what do you do there?
My general duties include possibly screening evidence for the biological presence, such as blood, semen, or saliva, or swabbing an object for possible skin cells, performing all steps of the DNA process, writing reports, and testifying as needed.
Now, when you indicate performing all steps, can you describe for us, is that a common procedure that you follow in performing a DNA analysis?
Yes, it is. We follow all of our protocols and procedures, and I have been trained to full competency in all steps of the DNA process.
Now, before we get into that, based on your expertise, what is DNA?
DNA is the basis of what makes us who we are. It's kind of like the genetic blueprint. You get half your DNA from your mom and half your DNA from your dad. And no two people have the same DNA profile except for identical twins. DNA can be found in every cell in the body except for mature red blood cells.
And what is DNA analysis?
DNA analysis is when we perform 4 steps of the process to then result in a DNA profile. So the first step of DNA analysis is extraction. And that's where we separate the DNA from the rest of the cellular components. The second step is quantitation, and that's where we determine how much DNA is present in the sample. The third step is amplification, and that's where we make millions of copies of the locations that we do our DNA testing for. And the fourth and final step is analysis and separation, and that's where we're able to look at the DNA in graph form and make comparisons to known samples if they had been submitted.
Now, you indicated that there were these 4 steps to result in a DNA profile. Are there different possible DNA profiles that may be developed?
Yeah, the different results for the end of a DNA process. So first, you could have a single source of DNA, meaning that the DNA arose from just one individual. You could have a mixture of DNA, meaning that the DNA arose from more than one person. And at the Michigan State Police, we will still make comparisons up to mixtures of 4 individuals. We could have the result where no DNA types are obtained. We could also have some DNA types that were obtained, but it's too partial of a sample or too partial of a profile to make comparisons. Or we could have kind of the last one is we could have too complex of a mixture, meaning that so many DNA types are present that it's just too complex and we don't make any comparisons to that result.
Now, following developing these DNA profiles, how do you go about attempting to identify whether or not a known sample is part of a DNA profile that you've developed?
So first we'll look at we'll determine if that profile, a DNA profile, is suitable for comparison purposes. Once we determine that it is, we'll then make a visual, we'll do a visual check to see, and then we perform a statistical calculation called a likelihood ratio. And a likelihood ratio is where we compare two very specific scenarios to see which of those specific scenarios best describes the DNA that was detected. So a likelihood ratio is set up similar to a fraction, with one scenario on the top half of the fraction and one scenario on the bottom portion of the fraction. And in the simplest terms, the top half of the fraction typically is, given the evidence, is this person a possible contributor? Or the bottom part of the fraction, given the evidence, is this person not a possible contributor? And when we determine the likelihood ratio for each of those, the larger number, either the one on top best describes the evidence, or if the larger number is on the bottom half of the fraction, that scenario best describes the evidence.
In regards to these likelihood ratios, are they then also described in a qualitative equivalent?
Yes, we have a qualitative equivalent that we also give for each of them, and that chart is listed on the final page of our report.
And talking about this report, after you go through and conduct these analyses, determining or making comparisons if possible with the profiles that have been developed, do you author a report summarizing your findings?
Yes, I do. I author the report, and then that report goes through a technical review by another trained scientist who's fully trained in all aspects of DNA analysis. And then there's a final review of the administrative check as well. And that person who completes that in Grand Rapids is also fully capable and trained to understand the DNA process as well.
Another thing to follow up on, you indicated that DNA is present in every cell in our body besides, I believe you said, the red blood cells. In talking about different items that you may be performing a DNA analysis from, are there some where you would anticipate it to be more likely where there would be a DNA mixture as opposed to other places?
I mean, I don't have any preconceived notions on what a DNA profile is going to look like until it's through the final step of analysis. And just to clarify, it's mature red blood cells that do not have a DNA present in them, not red blood cells. It's mature ones.
So in regards, I guess just to follow up with that question, do you find it surprising if you were to find multiple contributors on a piece of clothing for DNA?
Again, you know, it depending on the nature of the clothing. I mean, if it was packaged, we may not find any DNA profile present on that clothing. So typically clothing, you could have many individuals who have nothing to do with the crime event that could be part of that. But you can also, you can easily have a DNA profile from a single source or no DNA profile. I mean, any type of DNA piece of evidence could have any of the listed conclusions or results that I previously stated.
Now, turning to the matter that we're here for in court today, did you perform a DNA analysis in a case involving a victim of Todd Schwarz and a suspect of Ethan Dingman?
Yes, I did.
I'm going to briefly share my screen, and I'm going to show you what's already been admitted into evidence as People's Exhibit 14. Can you see that?
Yes, I can. It looks like the first page of my report.
If I scroll down to the bottom, does that still look like your report?
Yes, it is. I can see my signature right above my title and email address.
So looking briefly at the DNA analysis that you conducted in this case. Starting with, well, first of all, in regards to the notations that are used, we see that with the shoe swab, pant swab, with each of these, there's a lowercase letter that follows each of the numbers listed in the report. Can you describe for the court what those lowercase letters signify in the report?
Well, for example, each case is given an individual case number when it comes into the door of our laboratory. This case was given GR 19, GR standing for the Grand Rapids Laboratory, 19 meaning it arrived in the year 2019, and then the following 7142, just the next available case number. So that's how each of our evidence profiles start. And then, for example, the shoe swab, the first swab is 1D, and 1D would be the DNA cutting that was prepared by my colleague, Paul Donald. And then once I performed DNA extraction on that sample, we then changed that number to the laboratory number, then 1E, with the E standing for the DNA extract, meaning the extracted DNA, in which I'm able to visually view a graph of that DNA profile and make comparisons.
Now, in performing your analysis in this case, were you able to develop a DNA profile from GR19-7142-10DA, the swab from Ethan Dingman?
Yes, I was.
And in regards to GR19-7142-13E, were you able to obtain a DNA profile from that item as well?
You said 13E?
Yes.
Yes, I was.
And was that in order for the purposes of identifying related to Schwarz?
Yes, that 13E was came from the blood sample taken from Todd Schwarz.
Now, were those the two profiles that you then used to do your analysis of any other DNA profiles that were developed throughout the course of your analysis?
Those were the only two known sources of DNA that were used for comparison purposes against the evidence profiles that we also performed DNA analysis on.
Moving to GR19-7142-1E, the shoe swab. Were you able to develop a DNA profile from that item?
Your Honor, may I please refer to my report at this time?
Certainly.
Thank you so much. Yes, I was able to develop a DNA profile from item 1E, the shoe swab, and that DNA profile was from a mixture of individuals, and that mixture was from 2 people, and at least one of them was genetically typed as a male.
And so then did you do a comparison with your known DNA profiles with the DNA profile that you developed from the shoe swab?
Yes, I did. The first comparison, we did each of these comparisons separately. The first comparison I did was comparing the DNA profile of Ethan Dingman, and the DNA profile of Ethan Dingman was excluded as a possible contributor to the mixture of DNA obtained on the shoe swab.
So what does that mean?
That means he is not a contributor to that sample. He is fully excluded.
And in regards to the profile from Todd Schwarz?
So for this case, I set up 2 scenarios to see which one of those best describes the evidence that was detected on the shoe swab. The first scenario, or the one that would be on top of the fraction, the DNA obtained from the shoe swab was from Todd Schwarz and one unknown unrelated person, recalling that this was a mixture of 2 people. So we're just needing each part of the fraction will contain at least 2 individuals. So was that DNA from the shoe swab best explained as originating from Todd Schwarz and one unknown unrelated person? Or was that DNA that was obtained from the shoe swab best described as originating from 2 unknown unrelated people, neither of whom are Todd Schwarz? And based on the DNA results for the shoe swab, it is approximately 72 octillion times more likely it originated from Todd Schwarz and one unknown unrelated person than if it originated from 2 unknown unrelated people. And for clarity's sake, 72 octillion is 72 followed by 27 zeros. And based on that calculated likelihood ratio of 72 octillion, there is very strong support that Todd Schwarz is a contributor to the DNA profile from the shoe swab.
Moving on to the pants swab, GR19-7142-3E, were you able to develop a DNA profile from that item?
Yes, I was. The DNA profile obtained from the pants swab was again a mixture of DNA, meaning more than one person contributed. And that mixture was from 3 individuals, at least one of whom was genetically typed as a male. So again, I separately compared the 2 knowns that were submitted for this case. So the first comparison I did was looking at the DNA profile of Mr. Dingman. So the 2 scenarios that I compared in this situation or in this scenario were, again, reminding that this is a 3-person mixture. So both the top and the bottom part of the fraction need to have 3 individuals as part of the likelihood ratio. So was the DNA obtained from the pants swab better described as originating from Mr. Dingman and 2 unknown unrelated people? Or is that DNA that was obtained from the pants swab best described as originating from 3 unknown unrelated people, none of whom are Mr. Ethan Dingman? And based on the DNA results for the pants swab, it is approximately 2.6 billion times more likely it originated from Mr. Ethan Dingman and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And based on that calculated likelihood ratio of 2.6 billion, this analysis provides very strong support that Mr. Ethan Dingman is a contributor to the DNA profile from the pants swab.
And in regards, oh, go ahead, no, go ahead.
I was just going to say, the next DNA profile that I then made comparisons to was that of Mr. Todd Schwarz. And again, I set up that fraction in a similar manner. Was the DNA obtained from the pants swab best described as originating from Todd Schwarz and 2 unknown unrelated people? Or is it better described as originating from 3 unknown unrelated people, none of whom are Todd Schwarz? And based on the DNA typing
Let me stop you.
Oh, sure, sir.
Lost me. We're doing interpretation of 71423E pants swabs. Okay, so it goes to the next page.
Yes,
That's
yes. Now we're
still-
on the top of page 3, sir.
Page 3. Okay, got it. Okay. Go ahead, I'm sorry.
Oh, no, that's fine. Thank you. Based on the DNA results obtained from the pants swab, it is approximately 920 septillion times more likely it originated from Todd Schwarz and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And 920 septillion is 920 followed by 24 zeros. And that calculated likelihood ratio provides very strong support that Todd Schwarz is a contributor to the DNA profile obtained from the pants swab.
In regards to a sample like this, where you have 3 individuals contributing to a DNA mixture and you're comparing it with 2 different known DNA samples, why is it set up where it's with one of the known samples and 2 unrelated unknown contributors for the first hypothesis in each of them, as opposed to the 2 known contributors and a 3rd unknown contributor?
That's just the policy that we go by on how we set up our scenarios. At the end of the report, we also say if there would be another scenario that you'd like us to process or make comparisons to, we can always do that given time permitting. Unfortunately, in this case, that specific scenario in which you just described was not done. That would need to be requested, and we could do that in the future, but that was not done. So again, because we're looking at 2 very specific scenarios, I can't give you a calculated likelihood ratio, for looking at both Mr. Dingman and Mr. Schwarz as possible contributors at the same time at this time.
All right, well, can I have a question? Because this was what I was struggling with before. So we know from the pants, one of the samples is a match to Todd Schwarz, one of the samples is a match to Todd Dingman, or to Ethan Dingman in that profile. And then there's a 3rd unknown contributor that isn't either one of those people. Is that correct?
There's a third person that we don't, right, that I have not compared, and there no other knowns were submitted for this case. So I only had 2 known individuals to make comparisons to. So yes, a third person, you could say that there's still, we could do more comparisons.
All right. Is there a profile of that third sample that could be compared to other samples?
We compare when we're setting up likelihood ratios, we compare to the total mixture. So yes, we could compare we could compare additional individuals as well.
Is it a sufficient sample that it could be run through the CODIS system to see if there was a match with it?
No, these samples are ineligible for CODIS. They were removed from the suspect themselves, and we're not allowed to put in DNA profiles that were removed from the suspect, samples that were taken from him. So none of these samples were able to be run through CODIS.
It is that it isn't possible, it just isn't part of the protocol?
Well, the FBI sets the regulations and rules of what we can put into CODIS. So one of the first rules was a crime committed? That obviously the answer is yes, a crime was committed, so that meets that criteria. Then we also need to know that we're putting in the punitive perpetrator. And also one of the other rules is it has to be like left at a crime scene. It can't be removed from a person. We couldn't remove an item of clothing from the suspect's house, knowing that it's in their possession, that then enter something into CODIS. Now, these samples were taken from the suspect, and so none of them can be entered into CODIS.
Thank you. All right, Ms. Shepard.
Thank you. Moving on to the lens swab, GR 19-7142-7AE. Were you able to develop a DNA profile from that item?
Yes, we were. That DNA profile originated from a single individual, so just one person that genetically typed as a male. Ethan Dingman was excluded as a possible contributor to that sample. And the next likelihood ratio calculation I set up was that DNA obtained, that single source of DNA obtained from the lens swab best described as originating from Todd Schwarz, or was that DNA sample originating from the lens swab best described as originating from an unknown, unrelated contributor, not Todd Schwarz? And based on the DNA results for the lens swab, it was approximately 150 octillion times more likely it originated from Todd Schwarz than if it originated from an unknown, unrelated person. And 150 octillion is the number 150 followed by 27 zeros. And based on that calculated likelihood ratio, the analysis provides very strong support that Todd Schwarz is the contributor to the DNA profile developed from the lens swab.
Moving on to GR 19-7142-8E, the shirt swab. Were you able to develop a DNA profile from that item?
Yes, I was.
And what were you then able to compare that with your known DNA profile?
Yes, I was. That DNA profile that originated from 8E, the shirt swab, was a mixture of DNA that originated from 3 individuals, at least one of whom genetically types as a male. So again, I set up the scenario first comparing the DNA profile of Mr. Ethan Dingman. So the 2 scenarios I compared to see which best describes the evidence were the first scenario, given that DNA evidence of the shirt swab is that best described as originating from Mr. Ethan Dingman and 2 unknown unrelated people, or is that DNA obtained from the shirt swab best described as originating from 3 unknown unrelated people. And based on the DNA results of the shirt swab, it was approximately 1.6 octillion times more likely it originated from Ethan Dingman and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And 1.6 octillion is 1.6 with 26 zeros. And given that calculated likelihood ratio, there is very strong support that Mr. Ethan Dingman is a contributor to the DNA profile obtained from the shirt swab. Next, I compared the DNA profile of Todd Schwarz. So the two scenarios that I set up were on the top part of the fraction, given the evidence of the shirt swab and the DNA detected, is that mixture obtained best described as originating from Todd Schwarz and 2 unknown unrelated people, or is that DNA obtained from the shirt swab best described as originating from 3 unknown unrelated people, none of whom are Mr. Todd Schwarz? And based on the DNA results obtained from the shirt swab, it was approximately 11 billion times more likely it originated from Todd Schwarz and 2 unknown unrelated people compared to if it originated from 3 unknown unrelated people. And given that calculated likelihood ratio of 11 billion, this provides very strong support that Todd Schwarz is a contributor to the DNA profile from the shirt swab.
And finally, in regard,
Let me stop you right. So, and there's also 1 unknown DNA contributor in that sample as well. That's not Dingman or Schwarz.
Yes, because that was a mixture from 3 individuals. And again, this could not be put into the CODIS system, but if additional knowns were submitted, we could compare the total mixture to that mixture. We could compare an additional individual to the total mixture detected in the shirt swab.
All right, now also just a minute. I'm not sure which shirt we're talking about. There's the plaid green and green shirt. There's mention of a bloody sweatshirt. Officer Donald testified about a t-shirt with writing. I don't believe we have any evidence, a t-shirt with writing on it. So I'm not sure which shirt this is that's being analyzed.
Looking at, I don't have a copy of Mr. Donald's report in front of me, but looking at the chain of custody for the entire case file, this item originated from, the DNA extract 8E originated from the shirt. And I can see that item 9 was from the sweatshirt. So I'm not sure if there was an additional shirt that was submitted, but we had a shirt and a sweatshirt, and this is from the shirt.
All right, well, we have, okay, I'll just leave it at that. We have an uncertainty as to what shirt is what.
Yeah, I guess that would have been something for Paul to answer since he took swabs of these items. I never saw the actual shirt. It said a plaid shirt or a shirt with writing on it. So this is the evidence description I was given that's in the total case file.
Thank you.
and then moving on to item GR 19-7142-12E, the fingernail swabs. Were you able to extract a DNA profile from that item?
This DNA profile, we did perform all 4 steps of the DNA process. However, a DNA profile was not obtained from the fingernail swab, item 12E.
Now, in regards to instances where there are potential unknown contributors to a DNA mixture, are there instances where an unknown contributor can never be identified?
Yes, there are. That happens very frequently. Many times there could be lingering DNA on objects that have nothing to do with a crime event. For example, if something happened to me and there was a crime event, but I gave my 6-year-old a hug earlier in the morning and my shirt was submitted for DNA testing, there could be DNA present from my 6-year-old that again has nothing to do with the crime incident itself and is just present kind of in the background of that object. And one, we never know the full life history of objects before a chain of custody is submitted or started once the items are submitted. So again, it's not uncommon that you could sit on a park bench and pick up a DNA profile that again has nothing to do with the crime event itself, especially on clothing of this nature, like a shirt, pants, or even just walking around with shoes, that we will never know the true DNA profile or who that DNA profile may belong to.
Thank you.
Is it true that it also could be related to the crime itself? And there's no way of knowing that.
I mean, I don't have any way of knowing that. I wasn't present at the time of the crime. So yes, it could, I mean, I guess you're right, sir. It could possibly have nothing to do with the crime event, or it could possibly have something to do with the crime event. But since these samples are ineligible to be put into CODIS, we would need known submitted for direct comparison in the laboratory here to ever know if somebody could possibly be a contributor or not a possible contributor to these mixtures.
Thank you.
Thank you, Ms. Schmidt. I don't have any further questions. Mr. Weis may.
Just a couple, if I may, Your Honor.
Yes, certainly.
Ms. Schmidt, the work that you do in the lab is, at least in no small part, in some part, dependent upon the work done by the officers collecting the materials that are ultimately tested at the lab. Is that fair to say?
Or, I mean, I don't submit any evidence to the laboratory for testing. So yes, the people that are on the scene, the officers on the scene, or, you know, the evidence collection people are a vital part of this process.
So hypothetically speaking, if I'm an officer and I'm going to collect shirts, pants, shoes in sequence, and just if I have an area of a table and I'm going to lay them out to photograph them, and I put a piece of paper down and across the table, and then I put an item on it, photograph it, take a second item. Would you want me to change the paper that I have between the items and the table before I process each item? Would that be optimal for your work in the lab?
Yes, that would be optimal, just like we always suggest to the officers collecting the evidence to package items separately as well. Now, sometimes when, for example, pants, like if a belt was attached to the item, I mean, that's how they were taking them off. So that's not necessarily as problematic. And certainly like shoes currently with shoelaces, again, you wouldn't have to like remove the shoelaces from the shoe, but yes, we wouldn't want to commingle or place down on the same piece of paper multiple items of evidence.
Same line of thought. Would it be optimal for me to change rubber gloves between touching one item and another and placing each item in a bag for the next step?
That would be optimal, or you could bleach your gloves down in between touching them as well.
And this
Well,
would again be to avoid commingling?
Or yes, it would be. So you would be, each item would be being touched. Like, so if I were performing analysis on the items, I would open a single bag, and the single bag would preferably have just one shirt in it. I would have a clean piece of bench paper out. I would have new or freshly bleached gloves, and then all of my utensils to examine that item would be cleaned, freshly bleached down items. Now, certainly, again, like I had previously said, it's not always possible, but in this case, if it could be collected that way, that would be optimal. Now, many times we do get something where these items were found, say, in a dumpster. Now, certainly when they're in the dumpster, they're all together, but then best practice would indicate, let's separate these into different bags when we submit them to the crime lab.
And this commingling would allow for a transfer of DNA.
Yes, anytime two objects come in contact with each other, there could be a possible transfer of DNA. That is possible.
And getting to your example that you gave, I was sitting on a park bench. So safe to assume then that these obvious touch transfers or transfers of DNA very easily can occur?
Sure, that could be, yes, it could. I mean, obviously, when you go to sit down on a park bench, you're not putting like a clean piece of bench paper to sit on. You're not bleaching down the bench itself. So yes, you could have DNA transfer that the person prior to sitting on the bench, DNA could transfer that way as well.
Thank you very much, ma'am. I appreciate your time today. Nothing further, Your Honor.
All right, Ms. Shepard, anything further for Ms. Schmidt?
No, thank you, Your Honor.
All right, thank you. You mentioned additional report. Ms. Schmidt, you're free to go. I'll remove you from the feed and you can go back about your business. Thank you very much.
Have a nice day.
Thank you.
Yes, Your Honor. Pursuant to MCL 766.11B1D, we would move to admit into evidence GR 19-7142, record number 1. Again, I was waiting to send a copy to the court before, waiting for confirmation one way or another from Mr. Weis to see if we needed to discuss this with you on the record or if he would stipulate to it. I never heard back from him. However, I am prepared to email a copy over that in addition to sharing it on the screen. I am prepared to.
What is it? What is it?
It's a laboratory report involving the on-scene investigation on the day that Mr. Schwarz was found inside of the garage.
Mr. Dingman, there is a rule which she cited in the Code of Criminal Procedure, which allows laboratory reports to come in under limited circumstances at preliminary examinations without the big laying of a foundation. And so it's for preliminary examination, probable cause purposes only. That's how we got the first 2 reports, and then we ended up taking testimony about them. This is a report I have not seen, which they're asking to admit under the special exception for preliminary examinations. Mr. Weis, what's your position regarding this exhibit?
I believe that report pertains I understand the rule that's been cited. I fail to see any relevancy with respect to the preliminary examination.
Anything further you wish to comment regarding that?
No, Your Honor.
So you won't stipulate to it?
No, Your Honor.
All right, well, it doesn't necessarily require a stipulation, but he argues that it's not relevant. What's your response to that?
Our argument is that it is relevant. It continues to describe the condition of Mr. Schwarz as the forensic technicians found him when they were conducting the investigation on scene. It is their laboratory summarization of what that is, in addition to the additional information that they took into consideration while performing that evaluation. It's a laboratory report by the Forensic Science Division of the Michigan State Police, specifically MCL 766.11B, does indicate that, except for the police investigative report, which this is not, A report prepared by a law enforcement officer or other public agency. Reports permitted under the subdivision include, but are not limited to, a report of the findings of the technician of the Division of the Department of State Police concerned with forensic science, a laboratory report, as well as other reports that are listed. So it clearly falls under the rule of 766.11b. It's relevant to the findings that they made there on scene that day. And so the court should be able to consider this report as it's making the determination of probable cause in this case.
Is there also a concern about hearsay evidence that this report is purporting to show what? One of the concerns I had, and one of the reasons I gave you an additional week, is I don't know anything about the scene. I have some little snippets of testimony. I don't know if there was a car in there. I don't know if it had a dirt floor or a cement floor. I don't know if there was windows open. I don't know if there was a light on in there. I heard testimony about bloody footprints on the floor. I've seen no pictures of bloody footprints. That's what I mentioned last week when I said there was no there. There's just a body in a garage, and the rest of it is unknown, at least unknown to me. He's objecting to this admission at this point. The people that are making these conclusions aren't here, and I haven't seen the report, so I can't look at it and say, yeah, this is hearsay, or yes, it isn't. You quoted the rule accurately, except for the police investigative reports, a report prepared by a law enforcement officer or other public agency. The reports include, but are not limited to, the report findings of a technician of the Division of the Department of State Police concerned with forensic science, which appears to be what this is. A laboratory report, a medical report, a report of an arson investigator, and an autopsy report. So it does appear to be allowed by the specific court rule. It went into effect, I think, after I was prosecutor and after I'd become judge.
Your Honor, just to follow up on the hearsay concern, the rule explicitly states in section 1, the rules of evidence apply at a preliminary examination, except that the following are not excluded by the rule against hearsay and shall be admissible at the preliminary examination without requiring the testimony of the author of the report or authentication.
That was the purpose of it. So I will admit the report, which I haven't identified yet. It is to be People's Exhibit number 15.
Yeah.
All right, you may publish it.
I've also, for the convenience of the court, emailed a copy of it to Your Honor as well as Mr. Weis, so that he is CC'd on that communication with Your Honor.
Well, this changes everything. At the 11th hour and the 59th minute, you put in the evidence that I've been waiting to hear about. As I said, I know nothing about what happened at the crime scene. No description of the garage, nothing. And you rested, and I gave you an additional week, and I guess the additional week led to your admission of this. So I'm going to have to read this carefully. And it may affect my ultimate thinking about what to do here. So I'll receive it, I'll print it off my email. Let's take a recess until, and Mr. Weis, you've seen this before, but you didn't know it was going to be admitted until earlier today. Oh, this is pages long. But you've had a copy of this, is that correct?
Yes, Your Honor.
Okay. All right. let's take a recess until 3 o'clock. I will review exhibit number 15. Mr. Dingman, you can have a break for a few minutes while I review this evidence. And this isn't a shoot from the hip kind of thing. I'm gonna have to read this carefully. All right, let's take a recess until 3 o'clock. Thank you. I'm gonna leave the light. Well, we have everyone but the defendant, so as soon as we get him, we'll be ready to resume. got a pen, but I still don't have the defendant. Hi, Deputy Bradford. Is everything okay with Mr. Dingman?
He's fine at home.
Okay, we're ready for him back in the room.
All right, well
All right,
done.
thanks. Bye. There we go. Welcome back, Mr. Dingman. All right, we are back on the record in the matter of People versus Ethan Dingman. All the parties that were present previously are present once again. Any further evidence, Madam Prosecutor?
People would briefly call Chief Brinker.
All right, Chief Brinker, let me swear you under oath once again. Would you unmute your microphone, please?
Yes, sir.
Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
Once again, would you state your name?
Mark Brinkert, Brinkert.
All right. Yes, you may inquire.
Chief Brinker, turning back to November 21, 2019, when you responded to the garage at 224 South Blackstone Avenue, can you describe for us the layout of that garage?
Sure. The garage is located off an alley, which is behind or to the west of the residence, 224 South Blackstone. It's a two-story garage / barn. I opened the walk-in door, which is on the east side of the barn. And that's how I was able to get in. Inside, typical barn, tools, had a cement floor. I don't recall if any windows were open or any other door was open, except for the walk-in door.
And in regards to that walk-in door on the east side, was that the only way that you found to be able to gain access to the garage that day?
Yes, it is.
Where was Mr. Schwarz positioned inside of the garage?
So as you walk in the door, he was approximately 3 feet inside the building. His feet were to the south of the building. His head was to the north.
originally testified on direct examination regarding making certain observations while they're inside the garage, including well, rather than me making an assumption based on potentially faulty memory, what, if anything, did you observe when you came into that garage?
The decedent was on the floor, his spine or on his back. There was a towel underneath his head and what appeared to be partial footprints in blood, which would have been on the west side of the body or the right side of the body near the head.
Did you also observe a pool of blood in the garage?
Yes, near the head.
About how far out, if you remember, did it extend?
Maybe 4 or 5 inches at the most.
And about how far outside, if at all, were these footprints on the west side?
Maybe 7 inches, 7 to 10 inches.
And if I just have one moment. Thank you, Chief Brinker. I don't have any further questions.
Mr. Weis?
Did you actually take measurements of these observations, or are you guessing today?
I did not take measurements.
Okay. So what are you basing your testimony on?
My visual.
Okay. And as I understand your testimony, you don't recall if the windows were open or not?
No, sir, I do not.
Okay. Thank you very much, Your Honor.
Well, this is 7 o'clock on the 21st of November. It's dark. Are there any lights in this garage?
If I recall right, yes, there was a light on, but I'm not 110% sure.
Was it already on or did you turn it on?
No, I didn't touch anything except to feel for a pulse.
All right. Was it dark outside?
When I first arrived, yes.
All right, thank you. Anything further?
No, thank you, Your Honor.
All right, any further evidence?
Your Honor, there are a series of photographs that are referenced in the People's Exhibit 15. I would argue that they're incorporated into that report by that reference. However, I would concede that that's not something that's clearly articulated one way or another by MCL 766.11b. My additional concern is that those photographs do contain photos of the deceased. And given the very public nature of these proceedings these days, because of the pandemic, with items being broadcasted to YouTube, that is why we've hesitated to put them on for sharing, given the public nature and the longevity of things once they go onto the internet. I did email Mr. Weis in regards to very limited photos for a stipulation. I never heard back from him in regards to those. It was not in regards to all the footprints, but particularly the footprints found on Mr. Schwartz's person. For that limited purpose, I would move to have those 3 photographs considered by the court as being incorporated in People's Exhibit 15, but do anticipate Mr. Weis may have some objections to that.
Mr. Weis?
I do object as to lack of foundation, Your Honor.
Yeah, we've been going after a moving target. I gave an additional week and then we heard something and now here's something else. And then I was reluctant to tell her how to conduct a preliminary examination, what I was looking for. It's their choice to present the evidence in the manner they wish to. Certainly no preliminary examination do they present all the evidence. It's just a matter of probable cause. I will just go with the report. At this point, I had more information, double hearsay, but it's admissible in the report. A little update from Chief Brinker. In looking over the notes, I had very little information about the crime scene, a brief. Anyway, your objection is sustained. We'll go with the exhibit as it is and proceed from there. Anything further?
No, thank you, Your Honor.
All right, now it's time for argument.
Thank you, Your Honor. Based on the information that was supplemented today, as well as the testimony that the court has already considered last week during the proceedings of this preliminary examination, the people do move for binder. As the parties have already, I think, if not stipulated to conceded, a crime has been committed here. That's not really where the inquiry of probable cause rests. We have both the forensic pathology report, People's Exhibit 1, as well as the testimony of Dr. Joyce D regarding the cause and manner of death of Mr. Todd Schwarz, that it was a strangulation, blunt force injuries to the head and to the chest that ultimately led to his death and that was ruled in the manner of homicide. So what we're left with is determining whether or not there's probable cause that Mr. Dingman is the individual who inflicted those injuries that caused the death in a way that's not excused under the law. The evidence in this case does provide probable cause for that. And I think it is important to take into consideration as we analyze both the evidence from last week as well as what we considered today, what the physical evidence that Dr. DeYoung described to us takes into consideration. So first of all, we have this blunt force injury that occurred. He testified that it was likely from either a push or from a fall and him hitting his head hard against the ground. That's why we have the laceration on the back of the head, as well as the contracule injury to the front of his brain. Taking that into consideration with the other injuries that she identified, he said that there was this bruising to the chest, the contusions noted in the chest. Most were colored purple or blue. However, there was a yellow-red abrasion to his sternum as indicated in the pathology report. And on her testimony, she indicated that likely this injury was inflicted during the perimortem period. The perimortem period being as Mr. Schwarz is passing away. Based also on the mechanism of the injury to the back of the head, we would expect that he's already on the ground then when this injury is being inflicted, and it's being inflicted in the manner of a blunt force injury. Now, the reason why I bring this back to the court's attention is to take into consideration the totality of the evidence that we have before us. We have footprints in blood, also based on People's Exhibit 15 on the decedent's body, there is what is an apparent footprint on his jeans. The foot is certainly capable of inflicting blunt force trauma in the form of a kick, of a stomp, of a swipe. When we're talking about these blunt force traumas, and it would be a reasonable inference to believe that the injuries that are occurring or these other blue contusions, purple contusions occurred at about the same time or in the time leading up to this yellow-red contusion. So as he is on the ground, it is a reasonable inference also then that the individual who inflicted these would then walk through the blood that is being that is pouring out of Mr. Schwartz's head at this point as he's already on the ground. We understand that this injury would have happened while he was still alive. And again, noting, while she said that it was impossible to completely give a time to when everything occurred, given that yellow abrasion to the chest, it makes sense that this would have happened after the injury to the head. So his head is already bleeding, already leaving that pool of blood for the individual who's there who intentionally inflicted these wounds to then walk through that blood and leave these footprints behind. We also have then the DNA analysis that was conducted on the shoes of Mr. Dingman. They were swabbed. They were identified to see if there was any presence of blood. We had the testimony from both Mr. Donald as well as from Ms. Schmidt in regard to what the result of those analysis was. We had the testimony that very little DNA, in fact, needs to be left behind because their testing instruments are so sensitive that they would be able to pick up even a very minute, almost unseeable amount of DNA present. We have the pictures of the shoes in regard to that. We also saw the pants, and that Mr. Donald, in fact, testified that the items were at the cuff and near the knee of his pants. So we're not talking about someone who had just walked in to an area to see this blood, but it's on his knee. It's not just on his shoes. It's near the cuff area of his pants as well. And that upon taking those swabs and being submitted to testing for DNA, that they did come back indicating the presence of Mr. Schwarz DNA on Mr. Dingman's clothing. Now, yes, in regards to particularly the shoe swab, that there are potentially two contributors to that DNA profile. Ethan Dingman, these are Ethan Dingman's shoes. He has been excluded as a person who's a contributor to that. However, there's very strong support that Todd Schwarz is a contributor to that DNA profile. Todd Schwarz being the one whose blood is all over the floor of the garage where he is found deceased. We had testimony from both Mr. Donald as well as Ms. Schmidt, how it's possible that we may never find out who another contributor is, that DNA can be picked up along any ways. Thinking specifically of shoes, especially about the testimony that we heard last week from Chief Brinker, that Mr. Dingman was known to be between different addresses, kind of roaming, not in a single location. His shoes are going many places. There's a chance his shoes are going to pick up DNA in many places. However, Mr. Donald indicated he does his best to find or to limit the amount that he's picking up to try to narrow down that DNA analysis. And what it comes back is, yes, one unknown contributor, but Todd Schwarz. And again, this is on Ethan Dingman's shoes on his person. The same goes for his pants. Again, the high likelihood that there's different DNA profiles that get left on individual clothing. However, in addition to finding Mr. Dingman's DNA on his pants, Mr. Schwarz DNA is found. And again, I think it's very important to note when we go back to People's Exhibit 13 and the testimony of Mr. Donald, it's not just random DNA that we're talking about. The sources identified it was a possible presence of blood, that then this item was swabbed and sent in order for the DNA extraction to be located. We talked about this last week, but then we also have these glasses that were recovered with a single contributor. Those glasses having the DNA of Todd Schwarz on them. And that also he was known to wear the same type of glasses, that these glasses were taken. There's probable cause to believe that these glasses were taken from Mr. Schwarz during the course of this assault. They maintained his blood on them and they were found on Mr. Dingman's person. I know there was some confusion regarding the shirt. The GR 19-7128 is not the shirt that there's a photograph of in evidence. It's a separate shirt. However, GR 19-7142-8 is a shirt as opposed to the sweatshirt that was described in GR 19-71429. That sweatshirt belonging to the victim, as both Donald testified, but also is supported by People's Exhibit 1 from Dr. DeYoung, who indicated that on Mr. Schwartz's person was a gray sweatshirt. So that can go back and can be referred to in terms of the external examination of Mr. Schwarz. I believe that the third item listed there is the gray sweatshirt that he was wearing. So taking all of these things into consideration, we have an individual who was found deceased on the scene. He's been assaulted. The assault was in the nature of these blunt force trauma as well as a strangulation injury. The blunt force trauma, again, we talked about it with being with a fall. Dr. DeYoung said she could not definitively say what object it was caused that blunt force injury to the chest area. However, we know that that's occurring towards the end of Mr. Schwartz's life because of that last groove that was left, indicating the blood's already pooling around his head, that the individual who's inflicting these, whether it is with their feet from kicking or stomping or using some sort of object, would then be able to walk through the puddle of blood, pick up Mr. Schwartz's DNA, and have that present on their clothing. The last thing that the people would refer to in regards to the People's Exhibit 15 is the information available there regarding Mr. Dingman's activity after calling 911, that he had been in the bathroom at the Shell gas station for a long amount of time. They did go and try to process that bathroom for the possibility of evidence, but that there were some things that were indicative of possibilities, but when subjected to further presumptive testing, were not coming back as presumptive. The people would say that the reasonable inference from that was that while Mr. Dingman was in there, he was able to have time to wash his shoes, to wash other parts of his body in order to try to get rid of this evidence. And as a result, it may not have been as apparent as if he had been apprehended as soon as this incident occurred. However, as Mr. Donald said, a small amount is all that's needed for them to be able to create these DNA profiles, and that's what they were able to get through the course of their analysis. So based on all of this, the people do believe there is probable cause to believe that Mr. Dingman is the individual who inflicted. Now, when we're talking about probable cause again, when we're in the course of a preliminary examination, what the people need to present is evidence supporting that the defendant perpetrating this crime. That evidence can be circumstantial. We can see the circumstantial evidence in this case, but the case law is clear in People v. Ferry 325 Mich. App 645 that evidence may be circumstantial. Also, the district court is able to rely on inferences in order to establish probable cause for the purposes of bindover, and that's located in the same case as well. So for these reasons, we do ask that the court would bind this matter over for court, even if in the court's own mind there was a matter. I should rephrase it this way. I believe the questions that have been raised at this point with Mr. Weis's argument last week that this is just a person who found a body, called 911, that's why his DNA is on there. That's a question of fact. The theory presented by Mr. Weis versus the theory presented by people present two different factual scenarios and factual questions. And those types of factual determinations need to be determined by the trier of fact, and that's a jury at the trial. And so we would ask that you bind the matter over to circuit court for these reasons. Thank you.
Mr. Weis?
Thank you very much, Your Honor. Well, Ms. Shepard certainly does state forth the standard for probable cause. I think that the arguments that are been offered and will be offered again here today are probative to that analysis in and of itself, certainly not to try to create any type of alternative theory or anything of that, but we have to explain or look at the facts as they're presented. And if we listen to the government's argument here today, it's, quote, again and again and again, and it's DeYoung and DeYoung and DeYoung. Dr. DeYoung didn't testify here today. Dr. DeYoung didn't have any supplemental information here today. None whatsoever. This argument has already been made. Your Honor has already indicated what he thought of that argument. So let's look at what we had here today. Paul Donald, biology. Okay. Came in and he just walked us through what he essentially read his report. There's very little probative or new information with respect to his testimony here today. And it has little, if nothing at all, to do with Dr. DeYoung. He came in, read his report, took a look at the photographs again, had the report last week, had the photographs last week, can't see anything on the photographs, can't really see anything on the shoes. Well, what about that spot on the bottom of the shoe? No, that's just dirt. Can't really see the blood, but it's there, it's spatter, it's small, it's microscopic. Oh, okay. We knew all that already. It was in his report a week ago. The only thing he says here today, he says, well, we can't see it. We have to use these special lights and whatnot to ascertain. And then this test, he described the test and the process and the procedures. The test and the process and procedures were interesting to hear and certainly, it was informative, but it offered nothing with respect to the probable cause analysis. Some of the stuff was on a knee. Okay, well, somebody found a body and somebody called 911 and DNA on a knee. and DNA on a knee on a person who finds a body and calls 911 and then stays on scene is probative of murder. Makes it more probable than not of murder. Donald describes cuffs, marks on a cuff, microscopic marks on pant cuffs, whatever. Again, somebody who's on the scene found the body. Then we heard from Ms. Schmidt. Again, very intelligent, capable, informative scientist. Walked us through the processes, walked us through the procedure, offered us some ideas as to, wow, maybe some of the ways in which the DNA that was collected here, in this case, wasn't really done up to optimal standards. But what substantively did she offer in terms of probable cause that Mr. Dingman did what Dr. DeYoung describes? Nothing. Nothing. Came in, literally read her report. Your Honor, I did the same thing you did. As she was going through it, there was one point in her testimony where like, wait a minute, there might be something new here. Oh, no, we got to turn the page. And she just kept reading. Okay, but we had this a week ago. And it doesn't add anything that makes, that's any indicative of a probable cause. Finally, we have the report from the scene, and Your Honor says, well, okay, maybe this is the 4th and 10 Hail Mary, or I forgot the analogy that Your Honor used, but if you go through this, there's nothing in this report that's probative of that Ethan Dingman did anything here. So Ethan Dingman, and the testimony is replete with the fact that, wow, we observed him and he was off in space, and he was saying all of these bizarre things, and his mood and tone and demeanor and mannerisms were all over the place. They're up, they're down. He's cooperative, he's belligerent. All of the police testified last week as to all of that during their dealings with Mr. Dingman. But we're here to think that this gentleman went to the Shell gas station and left a pristine scene, and that's the probable cause of murder. That Ethan Dingman committed the act described by Dr. DeYoung. The more we get into this and the more evidence we hear and the more people that come in and testify, the more exculpatory information comes out. Finally, we had Chief Brinker. Famous saying, well, I'm not 110%. Well, I came in through this door. I did note other doors and windows. Were they open? I don't know. Well, I think this was 7 inches. Did you measure it? No, just guesstimating. I'm not 110%. Same officer who was on the crime scene, I believe he testified last week for 3 to 5 minutes. I think it was less than 5, much closer to 3. Has a 2 minutes of questioning, or very brief questioning with Mr. Dingman. Comes back to, there's my guy, not 110%, but got my suspect. Your Honor, there is absolutely nothing that would link Mr. Dingman to this offense, to having committed this offense. He found the body, went to the Shell station, called 911, stayed on scene. What happens after that? It says a bunch of bizarre stuff, which Your Honor has really already indicated is probably more exculpatory than incriminating, and probably not going to be admissible anywhere down the road, if even here today, because he was in custody once he was taken from the front seat to the back seat of the squad car. Which leads to something even more problematic for the government here today. When we last left the court, we were hung up on DNA, where Your Honor seemingly had some, and I would describe it as Your Honor thinking out loud, which we all do, okay, on DNA, and whether this unknown donor might be relevant or whatnot. And Your Honor made a statement that Your Honor actually stopped at yourself and said, yeah, if it even matters. And I think that reaction is exactly right, and it doesn't matter. What matters here is this: if we get to that point in the case, the scene, the investigation, wherever, and Mr. Dingman's been questioned 4 times, and the 2 detectives stand up They take a 3, 4, 5-minute break, whatever it was. They go into another room in the administrative room. They talk to the prosecutor. Prosecutor says, okay, we got enough. Then we start seizing clothing and items and whatnot. If Your Honor doesn't think and didn't think there was probable cause coming into court here today, and today was all spent on DNA, we don't even get to the DNA testing if he's arrested, seized, searched, and his clothing is stripped to submit to the lab for that analysis if they don't have probable cause to arrest. Either you'd have to have probable cause for exigent circumstances. We don't even get to the lab report. Your Honor, this case cannot and should not survive bind over. It cannot and should not proceed to trial based upon the record that's been submitted to the court. I respectfully ask that you dismiss the case at this time.
Last word, Ms. Shepard.
Thank you, Your Honor. I do find it interesting in Mr. Weis's argument that while he considers much of the evidence that the people have presented, continues to ignore an important piece of evidence that the people have admitted, and that's that Mr. Dingman had Mr. Schwarz glasses with Mr. Schwarz DNA on his person. That's a fact that simply cannot be denied. It goes beyond a question of whether or not this person is calling 911. It shows how close he was at this time to the individual. It puts him on scene. And again, the DNA on his shoes puts him in the place of where this incident occurred. Second of all, and again, while I don't think this is necessarily relevant for the purposes of bind over, the items that were seized from Mr. Dingman's person were seized pursuant to a search warrant. So they had the probable cause. They had a search warrant issued by a magistrate that allowed them to seize these items. We would get this situation where then we have the DNA analysis that comes back with the DNA on Mr. Dingman's clothes. The DNA that shows is Mr. Schwarz DNA that ties Mr. Dingman not just to calling 911 on the scene, but the fact that he had contact with the blood on that scene of Mr. Schwarz, that contact came in the course of him conducting this assault against Mr. Schwarz that ultimately led in his death. There are questions of fact here, Your Honor, but again, a question of fact is for the fact finder to decide at a jury trial. This matter should be bound over to circuit court, and we ask that you would do so. Thank you.
Thank you. I wondered if you were going to mention the glasses. That's the single most compelling piece of evidence that there is. I'll get to that, but we don't even know whether they're Mr. Schwartz's glasses. And the standard, everybody understands, is a probable cause standard, not a proof beyond a reasonable doubt standard. So there are lots of unanswered questions that don't necessarily need to be answered if the people can come up with sufficient probable cause to bind the matter over. It doesn't really matter. Do the bloody footprints in the garage match the shoes? Is there other evidence that we don't know about? Eyewitness testimony or testimony from the 911 tape or testimony from people in the store or other things that doesn't matter. What matters is there sufficient probable cause here to bind the matter over, and it really rests on a couple of small samples of blood. Let's start with a time frame, and I may have done this a little bit last week, from the defendant's tenure in jail, which is now 595 days in jail. He got arrested on April 21st, and I had the same thought that Mr. Weis had. They did some interviews, and arguably everything said to the officers at the sheriff's department is inadmissible. Nothing was really strongly argued about that. Officer Nails said he gave 4 different statements, but he was in custody. He was mentally ill. The prosecutor described him as a paranoid schizophrenic. He was actually very strange. He's 19 years old. He'd been in the back of 2 separate police cars. They took him all the way to Centerville and took him inside to do a recorded interview, which was not recorded. And no one ever thought to advise him of his Miranda rights, but we aren't rising and falling on that because none of those statements are being considered here. I had the same thought Mr. Weis did. If the prosecutor had submitted for an arrest, I didn't know what happened. I knew Mr. Dingman was arrested. I knew Mr. Schwarz had died. I didn't know how he died. I didn't know if he was shot or stabbed or strangled or hit over the head. I just knew that he died. I didn't know anything about it. There was no probable cause affidavit. There was no bond sheet. There was nothing. He was simply charged on a short form open murder complaint saying he did kill Todd Schwarz, did murder. I had the thought that if the prosecutor had submitted for an arrest warrant, at the time they made the arrest, there wouldn't have been enough probable cause to arrest him. We certainly didn't have any of the DNA evidence you have here. So you take that out, you got nothing. You got a dead body and you got a young man that called it in. I don't believe there was probable cause at that time to make an arrest, but he got arrested. Sometime between 7:11 and 7:41, probably closer to 7:11, Chief Brinkert says on the hot mic, "I think I got my guy, I'm just not 110% sure." So within 20 minutes of the time he got there, Mr. Dingman was the suspect. So on the word of the prosecuting attorney with a non-recorded, non-Mirandized statement, the defendant is arrested. The magistrate sees him on November 22nd and bond is denied. Mr. Weis appears on the very same day. I don't know if he's Bill, they were trying to call on the phone, but Mr. Weis appeared very quickly thereafter. Preliminary examination was set for December 3rd, a pre-exam conference. And at that point, the officers were still finishing police reports. Mr. Weis was filing discovery demands. They were just trying to figure out what was going on. So it was set for a prelim on December 10th of 2019. And the prosecutor asked for a competency evaluation, said the defendant was a paranoid schizophrenic. I had engaged a little bit with Mr. Dingman in the early stages of this via this kind of a Zoom or Polycom link, and he certainly did seem very, very disoriented. So on December 10th, I ordered that he undergo a competency evaluation and set the pre-exam conference for March 3rd. On that day, I signed the order for competency evaluation. Then we got an input from the Forensics Center in January 31st. We had a first competency hearing on February the 5th, and the defendant was found to be incompetent. He was not able to assist in the understanding of the facts and aid in his defense. It was the opinion of the forensic examiner that the defendant was incompetent. So everything stops. That report was dated January 28th of 2020. He was so mentally ill, they couldn't do any testing. In my opinion, Mr. Dingman was incompetent to stand trial. He appeared actively psychotic, in which he displayed loosening of associations and an inability to discuss the events that led to his arrest in an intelligible manner. That was 2 months after the arrest. And my fear is, at that point, all the investigations stopped. The defendant got arrested. He was a suspect within 20 minutes. Within 2 weeks or 2.5 weeks, he was evaluated for competency, and it takes a long time. So we issue an order in February of 2020 that the defendant is incompetent. It takes all the way to August of 2020 before defendants admitted to the forensic center for treatment. He was awaiting placement from his evaluation in January to August. So we got updates. At that point, after August 18th, I believe it was after the, no, it was before the primary, it was after the primary election, but before the general election. The special prosecutor was appointed for Kalamazoo County, and Ms. Shepard is gracing us with her appearance on that appointment. And these are very difficult cases to inherit from someone else. So in October of 2020, the Kalamazoo County prosecutor is now responsible for the case. Mr. Marvin had been elected as prosecutor-elect, and he had had some very brief contact with the defendant. So he disqualified himself, and Kalamazoo was appointed. So I don't know what happened, if anything, between defendant's arrest in November and the time the special prosecutor was appointed in October. We got a treatment update in November 9th. He was still incompetent. We got a second 90-day report in February of 2021. He was still found to be incompetent. We got another report on April 9th of 2021, finding that the defendant had been returned to competency to stand trial. Mr. Weis had some objections to that. Judge Pattison held a comprehensive competency hearing, taking testimony, found the defendant to be competent, and with some struggles, the matter was set for prelim for June 1st. And as of today, the defendant has been in custody for 595 days with his bond denied. So finally, on June 1st, do we start to hear some testimony about what happened? That was the first I knew as to how the decedent died. Now, that's not necessarily unusual, but I came into this preliminary examination with no preconceived ideas about anything. I knew very little about it, other than the defendant was struggling with mental health issues. So let's go to the timeline of the day that this happened. November 21st of 2019, a 911 call comes into our central dispatch. I believe at 9:52. November 21st is a Thursday. It's dark out. It's presumably cold out. And they get a call of a medical. Trooper Burgoyes arrives at 6:55, and the defendant comes out of the Shell station. And in her testimony, he has a 1,000-yard stare, and he is not processing what was being said. He did say something like he'd been over there or something. But she told him to stand by the patrol car. Officer Brinkert is there, and he went in the garage through the side door and saw the decedent and some blood. I'm presuming there must have been some light on in there because it's still dark. I didn't know anything about what the garage looked like, or we'll talk about that in a bit. I got more information today. Officer Brinkert interviewed the defendant briefly outside the car. Somewhere during that period of time, between 7-11, he gets out of the car, and that's when he makes the statement, "I think I got my guy. I'm just not 110% sure." So Then he gets out of the car at 7:43:49, according to cross-examination, and says, I don't know if he's out of his mind or just a dumbass. So at that point, the defendant had been in the front seat of Mr. Brinker's car. Then he was placed in the back seat, locked in the back seat of the car while he went in and took pictures. There was some other interviewing, and that's when it says, I don't know if he's out of his mind or just a dumbass. Then he's taken out of that car and put in the back of Deputy Bingham's car. Then he was transported to the jail. And I wasn't clear whether Officer Brinkert transported him or Deputy Bingham transported him. Instead of going to the Colon Police Department, which would have been just down the street for further interview, he was taken to the Sheriff's Department, allegedly, so they could videotape the interview, which they failed to do. Then at 9:30-ish, according to Deputy Males, they start their non-Mirandized interview with a schizophrenic 19-year-old man. And that interview ends at 1:30-ish. And at 13:29, the defendant was placed under arrest after a brief consultation with the county prosecutor, and then he was given his Miranda warnings. On December 4th, the evidence was sent to the lab. On March 9th, those lab results were completed, and later the results were sent back in the reports. Officer Mail said the defendant made lots of random statements that made no sense, and he would go off on tangents. What I knew about the scene before today, Officer Burgoyce went in and looked at the scene briefly, saw a white male on the floor with his arms and legs at his side, a piece of cotton or pillow under his head, which was interesting to me. It's doubtful the defendant put that under his own head, or the decedent. Someone apparently put something under his head. She saw blood and bloody footprints and splatter marks. And according to Deputy Herman, there were pipes on the victim. There was a large tear in his blue jeans. His pant pockets were inside the pants. They searched the house, found some evidence of drug activity and some bananas. And I don't know, nothing to indicate that it was the scene of the crime. Then today, with the admission of Exhibit 15, we learn a little bit more about the crime scene. The crime scene response team arrived at the scene at approximately 2:21 p.m. on November 21st. A pre-scene briefing was conducted by investigating officers with the following information given. Hearsay and hearsay, but it is in the report and it's admitted. Investigators were initially called to the residence on a medical call. First responders discovered the decedent in the unattached garage of 224 South Blackstone Avenue. He was the homeowner, according to investigators. He was found lying on his back in a large pool of suspected blood around his head. There was some sort of cloth under his head. Footwear impressions in suspected blood were observed around the victim's head. There was also suspected blood splatter observed near the victim's body. Upon this discovery, responders backed out of the scene without approaching the body. Here's some more hearsay contained in the hearsay. Investigators advised the suspect had called 911. He had called from the Shell gas station located next door at 226 South Blackstone Avenue. He reportedly entered the gas station and went into the restroom for an extended length of time. The restroom was secured pending crime scene response team processing. So someone from the gas station told someone who told them that he'd been in the restroom for an extended period of time. And the prosecutor argues that he had time to go in there and clean himself up. We don't know how long he was in there. We don't know if it was before he called 911 or after. And there's no testimony that he was covered in blood or anything when he went into the Shell station. But the suspect was later apprehended. He reportedly had the victim's glasses in his possession and suspected blood on his clothing. The response team advised the suspect had been staying at the victim's residence on and off for the past several months. More hearsay on hearsay. The weather at the time was approximately 48 degrees with light rain. My questions about the garage. The garage of the residence was 2 stories and constructed of wood. The floor of the garage was cement. The garage had an entryway facing east and a sliding bay door located on its west side, leading to an alley that ran north and south. The decedent was located in the southeast portion of the garage. He was lying on his back with his legs oriented to the south and his head to the north. His arms were extended at his sides. He was wearing a dark gray sweatshirt with a lighter gray shirt underneath. He was also wearing blue jeans, white socks, and black shoes. Possible footwear impression was observed on the right leg of the victim's jeans near his knee. There was cloth under the back of the victim's head and a significant amount of apparent blood around his head. Footwear impressions, footwear 1 and footwear 2 were observed to the east and west of the victim's head. The impressions appeared to have been made in blood. There was suspected blood spatter observed on the floor, as well as several items in the garage near the body, including a shovel and a green plastic tote located to the north of the victim and a garbage can to the west of the body. There was an apparent observed wound on the defendant's chest, with some bruising observed on the chest as well. Somehow, the wound was observed on the back of the decedent's head as well. We know that the decedent had amphetamine, methamphetamine, and fentanyl in his bloodstream, which did not appear to contribute to the cause of death. So we know a little more about the scene. It was relevant to me whether the floor was dirt or cement. There's some argument that the defendant hit his head, but we don't know that. The testimony was it was a blunt force injury. He was also strangled, and someone placed a cloth or pillow under his head. I couldn't tell whether he died there or was moved there from somewhere else. The autopsy report says that liver mortis is dank and distributed dorsally, is dark, meaning he was on his back. So it didn't appear he died on his stomach and they rolled him over. He was on his back. He had cuts in his pants and a blood stain beneath the knee. He was alive when the head and neck injuries were occurred. Prosecutor argues somehow that there's some evidence that he was stomped on by a shoe, causing injuries to the chest. I don't know. I think that requires too many inferences. We don't really know what happened to the injury on the chest. She extrapolated Dr. DeYoung's statement about the yellow scuff mark. I'm not willing to follow that same inference upon inference. I don't know what caused the injuries to the chest. I don't know what caused the injuries to the head, but he died as a combination of strangulation and blunt force trauma to the head. The doors to the house were locked, something that I didn't understand. The keys were found in the yard in the rear between the house and the garage area. Trash and a duffel bag believed to belong to the suspect were found by the church. Officer Herman testified the defendant had apparently been sleeping under a foyer roof at the church in November. So I don't know what that means, if anything. Defendant made multiple statements, some which may be admissible, some which may be ruled to be not admissible, but he didn't make much of an inculpatory statement. One of the things I wanted somebody to say is, what were you doing at 6 a.m. on a Thursday morning in the dark in Todd Schwarz's garage? How did you come to find him in there? What were you doing? Why were you in there? Where did you come from? Where had you been? Who had you talked to? I don't know any of those things. I don't know if they were asked or not. The defendant was very difficult to communicate with, didn't seem to understand what was being asked, and his responses were often non-responsive. So I don't know what he was doing there at 7 a.m. at 6 a.m. on a Thursday morning in Todd Schwarz's garage. If somebody asked him, nobody told me. His first statement says it was Todd Schwarz. He had not seen, it had been a week since he has seen Todd. He is no longer staying there. He said, I didn't have anything to do with it. Well, first statement, by the car. Second statement is they put him in the front seat, and there's some conversation there. The third statement, I didn't have anything to do with it. Defendant's in the back seat of the car. Number 4, after Brinkert says, I don't know if he's out of his mind or just a dumbass, he comes back and starts to type the search warrant to search the house. Defendant said in this conversation, and it's arguably that he's in custody at this point, but he had not been Mirandized. This is the statement prosecution's resting much of their case on. And defendant opened the door, he said, he opened the door, saw Todd, stepped out, did not like what he saw, said he had not touched Todd, and he didn't know who would want to harm Todd or whether anybody was mad at him. It was in a very low tone and it was very hard to understand. So he says, I didn't go in there. That's important, is whether that's admissible or not. But I guess I'll take, for the sake of argument, this is the investigatory stage. But he wasn't free to go. He was put in the back of the car and the doors were locked. The windows were rolled up and he slid the panel over so somebody couldn't climb through like had been done. One of the officers here was involved in this, and they took off in their car and drove in the river, and it was all bad. Anyway, he was in the back of that car, and nothing inculpatory except he said, I didn't go in there, I didn't like what I saw, and I never touched it. So, you know from the lab reports that the defendant has the decedent's blood on his clothing. And that's really it, what the case boils down to. The shoe swabs, I thought that the shoes on the bottom were, there wasn't much I could see on there, and apparently none they could see. There was a trace amount of blood where the lab technician took a swab and a little bit off the top and sides, but we couldn't really see what it was. They certainly were not drenched in blood, like he was stomping on the defendant or walked around there or put something under his head. There were traces of blood on his shoes. There was someone else's DNA also. His own DNA was not on his shoes, but the decedent's was on there, and someone we don't know. And as we know from the lab technician, Ms. Schmidt, we don't know if that's just some random DNA or whether it's related to the case. There's no way to know. I did learn that there's no way to submit that unknown evidence into CODIS for determination. There's blood on the pants. There's Ethan Dingman's DNA on his own pants. Todd Schwarz's DNA on his pants. Again, they aren't blood soaked. They're traces of blood. Also, 2 other people have DNA on defendant's pants. So who is that? We don't know. Was it the officer that took his pants off? And Officer Weis, or Attorney Weis, makes an argument at this point. It isn't clear that this stuff is even admissible. I'm considering it for purpose of this case, but his argument is they didn't have authority to make an arrest, and they seized this subsequent or subject to arrest. Prosecutor pointed out that somebody got a search warrant to seize these items. I don't know what was in the search warrant. I haven't seen them. So although the glasses were removed from his pocket when they told him to empty his pockets when he was arguably in custody. But if he was in custody, they would have found it subject to arrest with the booking process. The glasses, I looked at them several times. We saw a picture of Todd Schwarz. We saw a picture of the glasses. Many years ago, I think I was an intern, about 1980 here, a woman was assaulted badly in Three Rivers, and a workman was working outside her house, and he saw her, and he came back later and assaulted her. He lost his glasses, and they did an analysis of the glasses for a prescription to determine the prescription of the glasses, and they used that prescription to link the glasses to the suspect who was ultimately convicted. So if they could do that in 1980, they certainly could do it now. But I didn't hear any evidence about any sort of prescription analysis of these glasses, other than they're argued that they're Todd Schwarz's glasses. They look like some glasses that Todd Schwarz had on in a picture. I don't know if they are Todd Schwarz's. Ethan Dingman wears glasses. I don't know if they were his glasses. But there were glasses found which are similar to glasses worn by the decedent. But I don't know if there's a prescription match or other evidence. And that evidence was troubling. Probably a powerful piece of evidence for the state. Let's assume, if we're assuming, the defendant walked in more than he said, bent down, looked at the decedent, got the heck out of there, and stepped in some blood and left. But why would he have the decedent's glasses? If he was asked anything about it, I don't know the answer to that. The forensic report with hearsay over hearsay says that he went to the Shell station and was in the bathroom for an extended length of time. And I don't know what that means. As I said, it was told by somebody who was told a police officer who told investigators, unknown, who put it in this report. They did investigate the Shell station. Officer Paul didn't remember whether he went to the scene or not, but apparently he did. That wasn't very good. He had actually been there, and Officer Paul applied Lyrocrystal Violet to the restroom at the Shell station. I think is something we used to call luminol, where you could see blood. A small area above the sink developed, indicating possible presence of blood. The area was tested with a hemostick with negative results for blood. So they didn't find any blood in the bathroom where the defendant was allegedly, for an extended period of time, cleaning himself up. Macbeth, out damn spot. It's hard to get rid of blood. So they didn't find any blood in the bathroom at the Shell station. And the defendant certainly wasn't blood soaked. Any blood they found appeared to be trace amounts. The shirts, there was some confusion. The shirt in the picture is apparently not the shirt with blood on it. And the shirt with blood on it isn't in evidence, and I'm not even sure whose shirt it was. So we've got the pants, the glasses, and the shoes with Todd Schwarz's blood on it. The banana doesn't bear any weight. There's no evidence the defendant was ever in the house. That doesn't appear to be the crime scene. And nobody asked the people at the Shell station if he bought a banana, or I don't know, but the banana doesn't really, I think, have enough to bear into this. So when you boil it down to its essence, you have the defendant who was schizophrenic and later found to be acutely psychotic. But that morning, I think his schizophrenia and mental illness was on display. He was not uncooperative. He called 911. I don't know what he said. He didn't leave. He didn't run away. He went next door and called 911. And then he stood there and he waited. The officer told him to stand by the car. On one hand, treating him as a voluntary statement. On the other hand, believing he's a suspect, but not 110% sure. And he doesn't go anywhere. He's not uncooperative. He's just unresponsive and often incoherent. So we have a defendant who calls in the crime scene and waits for everyone to get there. I don't know what time he went in the Shell station or how long he was in there. All we know is that he made the call at 6:52 and he came out when the trooper pulled up in a blue state police car and said, "It's Todd Schwarz and I didn't do it." And I don't know who did. The blood on the glasses is troubling. Again, I don't know whose glasses they are. I think there's a pretty good inference they belong to Todd Schwarz. Where they came from, how they came to be in the defendant's possession, I don't know. How did blood get on there? I don't know. We know the evidence technician was handling bloody evidence not very carefully. We learned there was a blood-soaked sweatshirt somewhere that I didn't learn about until late in the game. And the officer didn't change his gloves or the paper he was laying the evidence on. I don't know if that blood-soaked sweatshirt was in the same place at the same time. I don't know. So I've been struggling with this for the entire tenure of this case, at least once it started. I've been looking for the there, it's there. There may be a lot of other evidence that is available, but as I indicated, I'm only to consider the evidence that's admitted at the preliminary examination. as both Mr. Weis and the prosecutor said, it doesn't matter, at least for bind-over purposes, whether there's other sources of DNA in these samples. It doesn't matter whether the defendant's footprints match or don't match the bloody footprints on the floor. As the prosecutor stated, those are issues for trier of fact. So all I do know is the defendant called it in, denied that he did it, denied that he went in the building and has some trace amounts of the decedent's blood on him. And I do not believe that's enough to bind the defendant over on this charge of open murder. And I don't do this lightly, Mr. Dingman. I don't know if you did this, or I don't know if you didn't do it. I don't even know if you know that. But there is certainly more evidence to be gathered, and maybe there's more evidence here than I know about. But I don't find that the evidence presented here is sufficient to bind you over on a charge of open murder. And I don't take this lightly. I gave the prosecutor another week because I didn't want to just open the jail door and have you walk out, but that's what's about to happen. Mrs. Dingman, my recommendation would be that you come to the St. Joseph County Jail to pick Ethan up. Here's the 8th. Mr. Dingman, the prosecutor does have a right to appeal this. It's subject to an abuse of discretion standard, which is hard to find. And I've been, as I said, as careful as I could be with this evidence. I find that a preliminary examination was held on this date, and it was found that probable cause does not exist. To bind the defendant over to circuit court. This does not mean that the case is over, Mr. Dingman. Jeopardy has not attached. If this was to be a trial and a witness is sworn to testify, they cannot try you for the same offense. You've not been tried. You've been subject to a preliminary examination. And I found that there is not sufficient probable cause. If they can develop probable cause, you could be rearrested. I don't know where the state of this investigation is. I said my fear is once you went to jail and the case went to the forensic center, the investigation stopped. I don't know that, but I know at this point, I don't believe there's sufficient evidence. So the defendant shall be released from the St. Joseph County Jail. Now, let me say something else, Ethan. You didn't just magically get cured from your mental illness. There was a long struggle regarding your competency, and there was a greatly disputed hearing whether you're even competent. Competency goes to your state of mind right now. There's also an issue of criminal responsibility. What was the defendant's state of mind at the time of the offense? You need continuing mental health treatment. My strong suggestion is that you immediately contact community mental health for continued treatment. You're giving me the thumbs up, and I'm glad to see that because you're not just going to be cured when they unlock that door. You're going to be struggling. And I guess I have nothing more to say about that. I don't do this lightly. All right, the court has found there is not sufficient probable cause to bind this matter over at this time. Investigators are certainly encouraged to continue to investigate if it can be developed as to this suspect or another. This court or another court, probably Judge Pattison would hear any subsequent hearing. But I've signed the order that says examination was held and probable cause does not exist to bind the defendant over on the charge. All right.